The Public Defender's Office, Your Honor, represents approximately 80% of the detainees at the Fulton County Jail. Mr. Kenner is going to talk to you today about a couple of things, and we'll give you a little bit of an overview. He's going to talk to you about the services that his office provides to detainees at the Fulton County Jail. It's not just legal services. They provide a host of other services like mental health treatment, private investigators, social workers, programming. Mr. Kenner is going to talk to you about the importance of face-to-face visits to the job and the services that the Public Defender's Office provides. He's going to tell you that face-to-face visits with lawyers are happening now, and they have been for a while, even with some of the COVID issues they've been going on. I want to clear up early a misconception that I found in reading the papers, and that is there's no dispute that the Fulton County Jail is unsafe. There's no dispute that the Fulton County Jail is in various states of disrepair, and there's no dispute that detainees need to be moved from the Fulton County Jail to a safer location while it undergoes repair. Mr. Kenner is going to tell you that today, Your Honor. The dispute here is about where those detainees can be moved, Judge. We're going to go through some law with you today, but the Georgia legislature anticipated that a jail could be found unsafe at some point, and again, no one disagrees that the Fulton County Jail is unsafe. And the legislature codified a law to address that, and we cited in our papers. It's OCGA 42-4-4, and the section is A3. That section reads, "It shall be the duty of the sheriff to take all persons arrested or in execution under any criminal or civil process to the jail of an adjoining county or to the jail of some other county if the latter is more accessible, if the jail in his county is in an unsafe condition under such rules as are prescribed in this chapter." That is the statute that we are here on this mandamus petition to enforce. The plain language of the statute is what's key here, and it's three main terms. It's the word shall, it's the word county, and the word unsafe. Shall has a meaning that is interpreted as not including discretion. It directs the sheriff as to what he must do. Again, we agree as to the jail conditions being unsafe. The question here is about what does county mean? I think that's one thing, but that gets answered. As we noted in our papers, the Georgia Constitution defines what a county is, and it identifies counties as a body corporate and politic within the state, and it says that the number of counties shall be limited. There shall not be more than 159 counties in this state. And I think reading that provision, which consists of a basic definition of county, it shows in conjunction with the word shall that the sheriff does not have the authority to send inmates outside of the state of Georgia just because his jail is in an unsafe condition. I suspect the sheriff's office is going to present some statistics and other testimony about the number and type of violent incidents in the jail, but those incidents don't mean that he can forego the law and move detainees outside of the state. The statute clearly sets forth what a sheriff shall do if he finds his jail is in an unsafe condition. There's nothing in the statute that permits the sheriff to move these detainees outside the state. You'll hear today that the sheriff's office, through its general counsel, told the Fulton County Board of Commissioners at a meeting a couple of weeks ago that the statute does not prohibit the sheriff from transferring detainees outside of state, and that's just wrong. I suspect you might hear today from the sheriff's counsel that the statute doesn't contain any language that expressly states the sheriff shall not move, but the statute doesn't say that because it doesn't need to. By codifying what the sheriff shall do, the Georgia General Assembly made its intent clear. It doesn't have to expressly state every prohibition. Mr. Kenner is going to go through the facts about when he learned that the sheriff when he first learned that the sheriff was considering sending detainees out of state. and what evolved from there that led him to seek this writ. And that he felt like he had no choice under the law other than to come to the court to get this law enforced. Once it became clear that the sheriff was taking active, concrete steps like visiting facilities, meeting with commissioners, et cetera, to try to put a plan in place to move detainees outside the state, Mr. Kenner wrote him a letter on September 8th, which he's going to talk to you about today, kind of outlining not only the effects that would have on the office, but that the law doesn't permit him to do so. That letter appears to have had no effect. And after a number of news reports and other public statements from the sheriff's office, Mr. Kenner had to come to this court. The sheriff has not only traveled to Mississippi to visit a facility, he's received draft contracts from that Mississippi facility. There are budgets and documents from that Mississippi facility that would lay out at least some of the terms under which detainees might be housed at that facility. You'll hear today that the sheriff told the Fulton County Board of Commissioners, Your Honor, that there are hundreds of available beds inside the state of Georgia. The issue is one of staffing. According to the sheriff, for those in-state facilities to take these detainees on, there has to be some solution for how to staff those facilities when they get this influx of detainees from Fulton County. But Your Honor, issues of staffing and cost are not an excuse to disregard the plain language of the statute. And the sheriff's office appears to be continuing to focus on facilities that are outside the state of Georgia. Now you're going to hear from Mr. Kenner that there's certainly far more than a mere suspicion that the Fulton County Sheriff's Office is intending to move these detainees. I've just previewed some of those facts for you. The public defender is asking you today, Your Honor, to make sure that the sheriff follows the law of Georgia so that Mr. Kenner's staff can service the needs of the detainees that its office represents. And he's asking you, Judge, to enter a writ of mandamus compelling the sheriff to conduct any transfers of detainees outside of the Fulton County Jail to counties within the state of Georgia in accordance with that statute. So
I want to focus in on that before we get real started in depth here. Obviously, at this point, we've now combined the request for an injunction and for mandamus. With that in mind, what is it exactly that you're hoping to walk out of here with today? And what would the language be that you propose?
With a writ directing the sheriff that any transfers of detainees out of the Fulton County Jail to another county has to be to another county within the state of Georgia in accordance with that statute, Your Honor. The public defender is not attempting to tell the sheriff which counties those need to be within the state of Georgia, just that it must be a county within the state of Georgia consistent with that law.
And you mentioned that you would expect that Mr. Kenner's testimony would include much along the lines of, at a policy level, why he believes this is necessary and the benefits of having detainees close to the county in which they've been charged. Is any of those policy arguments a factor in a mandamus petition like this?
Well, I think he's going to present to you more than just policy arguments, Your Honor. He has thought this through and has a number of concrete examples of how his clients could be put into jeopardy, legal jeopardy in another state.
No, I understand that, but what I'm saying is unlike an injunction where there's a prong that says the public interest and kind of the greater good to that extent, that's not really at play in a mandamus, is it?
No, I don't believe it is, Your Honor.
Okay. All right.
It's about enforcing a public right. And that is the mandamus statute that we cited in our pleading, Judge.
Okay. Thank you, Ms. Warner.
Sure.
Mr. Dreyer, anything you wanted to add as by way of opening?
Yes, Your Honor. Your Honor, and I Sheriff Labatt ran for sheriff of Fulton County to protect and serve and to keep people safe. Since taking office, the number one priority for the sheriff has been to protect the detained individuals at any facility. So above any other public policy priority for the sheriff, it is to protect individuals and his entire staff. Testifying today will be Mike Schotz. He is the chief of staff for the sheriff, and he has been an employee of Fulton County for 26 years. Mike Schotz will testify that they have taken extraordinary measures to try to keep the prison population safe, or the jail population safe. Number one, by reducing the number of detained individuals. We will tell the court about partnerships with the district attorney, the solicitor general, to do specifically lowering bonds if people are deemed not to be a threat to the community, to reducing charges if possible. And in some instances, the sheriff has a team, an inmate advocacy team, that has found individuals, and Your Honor probably has read about it too, that have been in the jail longer than they would have served if they were convicted the day they were arrested. So for those individuals, also trying to move them to a different status so that they can be released immediately. Including in that has been the Superior State and Magistrate Courts of Fulton County that have been good partners with that. In addition to trying to reduce the number of incarcerated people through those partnerships, they have pioneered a program to have like they call it a trustee program, where individuals are allowed to leave Rice Street for an annex facility, which is much safer, and then help out around the custodial facilities when they're doing that. They've also put a pre-arrest diversion desk in the Rice Street entrance. And then to be brief, Your Honor, the second things is rehabbing additional space in Fulton County. That first began with a protracted contract negotiations for ACDC, the Atlanta City Detention Center. And that was elusive to try to get that space, but politically extraordinary that space was obtained. What then happened, Your Honor, is the individuals that were detained at the South Annex were moved out of the South Annex because of the extra capacity that ACDC took. Then the South Annex was fully renovated. They call it a blitz renovation to restore the whole facility to make it as safe as possible. That just got accomplished in September, the beginning of September. Once that was accomplished, they have retained an emergency logistics management consulting company. They have a plan for renovating the entire Rice Street facility. There's 5 pods. The first one is to remove 1 North, the population there, to the South Annex. That has already happened. The 1 North is being completely renovated now, and it expects to be done in the next 15 to 30 days. When that 1 North, is renovated, the folks from the next facility will be moved over, and they will go through all 5 pods. Your Honor, candidly though, that building is in such dire straits that even this massive renovation is not a long-term solution. It's so bad right now from several standpoints. One is the philosophy that the building was created was the tower system where you look down, whereas a lot of the newer facilities have guards stationed within where the inmates are living to provide greater protection and monitoring. But it's so dire right now, Your Honor, that individuals can actually break through the wall at Rice Street. They can pull out rebarb and have used that rebarb as a weapon. So we do agree it is an absolute crisis, and this team is doing everything they can from all levels. After having done everything they can as fast as possible with rehab, which is still ongoing with the partners in Fulton County, they sought extra space.
And so let me pause you right there. So would you say then that in its current condition, that, as opposing counsel alluded to, that it's your position that the jail of this county is in a, quote, unsafe condition as it's described in 4244?
Your Honor, there's probably a lot of pending litigation that could be effective. So I'd say we're not going to contest that allegation, if that's okay, for the purposes of this today.
All right. So recognizing the current status without using those exact words, you were saying how this plan developed.
So thank you, Your Honor. So then once we've done the first two things, then there's been a continuing trying to get additional space outside of the county. And that started with our adjoining counties. Cobb County has opened up space, and we can go through, we'll go through all of them, Your Honor, but there is a crisis in staffing, and I want to get to that, but you'll see today a letter, we submitted it to Ms. Stu, the staff attorney, that the sheriff actually wrote a letter to every county in the state of Georgia asking for every available bed. And you'll see that it's been incredibly difficult to manage, but yeah, we've gotten 30 spaces in Oconee County. We've gotten one space in Gwinnett, one space in Newton County. They've done everything possible to keep people as close to home as possible. Okay. So there's just not enough space available to us. And it does go back to staffing, but it's not necessarily our staffing issue. We have the same problems other law enforcement agencies have. There's not enough people that want to do this job. Fortunately, the Board of Commissioners has been very supportive. We have been able to retain most of the people doing this job, but we have incentive pay. We're attracting new people. But Your Honor, we need 200 people right now, and even then, we wouldn't have access to enough space to keep everybody safe. So it's being faced across the state, and really with a lot of these facilities, Cobb County, for instance. They could take, there's a 500 max capacity there. They have an operational capacity of 228 people. That's the number of people that are there right now. We can't hire and put people in that Cobb County facility. They have to do it. That is what we're facing in many of these other places. The only place where we could actually hire and potentially increase would be ACDC. The problem with that, though, Your Honor, is a political problem as well. There was a very unique arrangement set up with the city of Atlanta that took a long time to come to fruition. But the city of Atlanta gets 60 days to review. We have to propose inmates line by line, one by one. And the city of Atlanta gets 60 days to decide if they're going to take them and they're not going to take them. And there's a lot of political pressure for them not to take people. So as much as we would love to max that out, because that's actually that facility, Your Honor, does have that new philosophy where you have guards embedded with people, and it should create a safer environment. But even when you're looking at all that, we would need to move, as of today, over 500 people out of Rice Street if we're going to make a meaningful difference on the safety there. Right now at Rice Street, there are 2,021 people, and that is beyond the operating capacity, especially considering that one north pod is completely emptied out while we finish that renovation. And that's going to last for a while, Your Honor. With the Folkston GO, and I'm only going to mention that briefly because that was in the original petition for writ of mandamus. That was dropped in the amended petition. So we assume today there's no objection to that. But with the Folkston GO and with the Mississippi facility, that's not something that originated in the sheriff's office. That was brought to the sheriff from the county manager, from the county COO, and asked if we would vet it. We did what the county chairman and county commission asked us to do, which was to vet it so that we don't have any problems with that right now. And then we're not doing anything further. They did send us a contract, but they send a contract to anytime we're doing a partnership of any type, we will get a proposed contract early on, just so there's a evaluation of if it's even viable. But that has been turned back over to the county, again, the chairman, COO, and manager's office, and they are vetting it. They are doing contract negotiations. They have to do the funding. None of that is on our plate. It's not currently with us, so that gets to kind of the imminent standard. This is not imminent in any way. And again, I'm going to, but your entire office has been incredibly responsive, and we know that you've looked at everything that's been submitted. So I won't go through the things that we've already submitted, but there's an extraordinarily high bar for mandamus. We have specifically challenged petitioner's petition on the basis of subject matter jurisdiction. There's not standing.
Right. And I know there's all those hurdles that you've contended, and I think we would get into those at the legal argument. And so recognizing those, seeing them in your motion to dismiss and the response that you filed to the injunction. So I feel like that we can get into in the legal phase.
Perfect.
But again, just so I know to kind of focus, what to focus on during the testimony here is the heart of the contention, assuming petitioner is able to get over these hurdles of whether we can even get to the merits of it. But the merits of it are 42-4-4. And I just want to make sure I understand what your legal position would be on this. You mentioned that you've sent out this letter to all the other counties. And so would it be your interpretation of that statute that the sheriff would have to have crossed off all 158 other counties in this state before we could even get to the idea of looking at Mississippi? And then the second part of that question would be, even if you did cross off all 158 other counties, are you still even allowed to look outside the state? That'd be the two-parter for you.
Yes, Your Honor. And thank you for getting to that. So with 2 points on that, the first is, it obviously says county, but county is not capitalized. There's going to be some definition in the Constitution, but every state has counties. In response to your question, we don't think that we would necessarily have to check off every other county ahead of us, but it's what the sheriff wants to do. It's what the sheriff would like to do. This is literally, if there was going to be a transfer to Mississippi, which is not imminent, I think probably Geo Folkestone seems to be a much better opportunity anyway, for a variety of reasons, slightly closer, but other things. Even if that's the case, though, I don't think there's not a lot of laws, so it's super fascinating, but I don't think this would bar us from transferring people to Mississippi. And I do want to address kind of a case that, getting to the substance of the argument, which of course, we don't think it even needs to be gotten to, but in that State of Georgia v. Blasingame that was cited by petitioner, it's super interesting, but it's not very clear. We've continued to do research on this, and that case, Westlaw does not say it's overturned, but I am 99% sure that case is overturned, and I'll circulate the case. I brought copies of it, but Blasingame says, well, it involves a bond financing deal, it involves the state, it involves a deal with the state of Florida entity. So there's a lot of ways to distinguish it. But specifically, the Georgia Supreme Court, after that 1956 Blasingame case, decided building authority of Fulton County v. State of Georgia. And in fact, that was a bond financing deal for the Fulton County Government Center, right across the street from us. That was challenged on a bunch of grounds. Blasingame was particularly cited in that. And the phrase in that bond deal that was one of the ones that was challenged was it allowed the Fulton Building Authority to, quote, contract with, quote, public corporations, both foreign and domestic. The Supreme Court overruled that Blasingame provision. And I think the reason Westlaw doesn't say it's overruled is because it also has good law on separation of powers. It's more frequently cited. But they specifically say that Fulton County is allowed to contract for the provision of governmental services with foreign and domestic corporations. And they read Blasingame to only apply to, like the situation in Blasingame, entity that is part of another state, such as the Florida Transportation Board or whatever it might be. So when you're looking at it, beyond this statute, there aren't any prohibitions, and this stuff is frequently done They're not, again, not a lot of law, but the 11th Circuit decided something in 2017, which I normally not try to cite here, but it was very interesting because the Walker County was trying to get out of paying the Chattanooga Hamilton County Hospital Authority $20 million for a financing deal. And they were citing Blasingame saying, hey, we can't contract with anybody out of state. And the 11th Circuit said no. And they came up with kind of a strained reading of it. They said that you can have a contract between two governmental entities and then have this Tennessee entity put the money in and then assign the rights to that contract to the Tennessee entity. So there's a variety of ways that you could still structure this to get done.
Just to be clear, this 11th Circuit case and this Blasingame, were they dealing with the statute that we're talking about
Your
today?
Honor. No,
So
Your
that's
Honor.
still kind of somewhat uncharted.
I agree. I agree.
But just to confirm, you're saying your interpretation of the statute, assuming we reach the merits, is that you don't have to, in kind of a domino effect, coursing outward from Fulton County, check off every other county in Georgia.
I think that's right, but I don't think there's a specific test on reasonableness, but I think that matters to some degree, and I think that's why we want to offer some evidence related to that.
Okay.
Because there's and mainly because there's so much discretion with you, Your Honor.
Maybe I'd really need to see something that says that, because it doesn't really show up in the mandamus chapter. But we can get into that. And then the other thing you're saying is that even assuming that there is no county in Georgia that will take somebody else from an unsafe jail, you can go beyond the boundaries of Georgia. So we could send them to Alaska if we needed to.
So it's interesting. I mean, the way I would typically read this, and I was a state legislator, I would put I just tend to read a reasonableness in this when someone's acting a particular way. So it would seem pretty unreasonable to send someone to Alaska. But Your Honor, if we're going to stick to this, there's not enough interpretations. We're going to be plowing new ground. And if this term county is not, the Georgia legislature knows that it's the counties that incarcerate in neighboring states and other states as well. This is pretty simple.
Well, I think in Alaska, they're called boroughs.
Oh, fair enough.
So
then Alaska would be off the table.
Okay.
I think we would stipulate to that too, Your Honor.
All right. All right. Well, let's get into it. Unless there's something else you wanted to have in.
No, thank you, Your Honor.
All right. Petitioner can call their first witness.
Yes, Your Honor, we call Maurice Kenner. And Your Honor, do we have a Zoom password so that we can show?
We need to add you as a co-host to
Okay.
make that work.
Do you swear or affirm that the testimony you shall give to the courts the truth, the whole truth, and nothing but you so help you God?
I do.
So if I can get you to state your name and spell it for the record, please.
Maurice Kenner, MauriceKenner.
Mr. Kenner, I'll give everybody a second because I think we were still checking on the Zoom. I have some stuff I can start with where I don't need the Zoom, but.
Let's do that.
Okay.
And we'll get it together.
Okay. Mr. Kenner, will you introduce yourself to the court, please?
Sure. My name is Maurice Kenner. I'm the Circuit Public Defender for the Atlanta Judicial Circuit, which encompasses all of Fulton County. I am responsible for the Office of the Public Defender within Fulton County. That office is right now just under 200 employees, to include attorneys, investigators, social workers, administrative staff, paralegals, social services workers. And I may be forgetting other folks, but it's a pretty large office.
And when did you become the public defender for the Atlanta Judicial Circuit? I keep wanting to call it the Fulton County Public Defender, but we don't call it that anymore.
Sure. I was appointed Circuit Public Defender by the executive director of GPDC, Director Omatoyo Ali, August the 2nd of 2021.
And then you've talked a little bit about the size of the public defender's office, but describe for the court what the public defender's office does, other than simply defend indigent individuals.
Sure. Our main mission is to zealously and professionally and ethically represent clients that are indigent in Fulton County. On top of representing clients in criminal court, we have the staffing to provide support services for some of the individuals that we represent. Some of the individuals that we represent have mental components to their case. So our social services division helps those individuals obtain the mental assistance that they need. They help our clients obtain housing, medication when they need. They help them, refer them to different organizations that also work with us, like PAD, Women on the Rise, and the Bell Project. And those organizations work with us to help our clients get released from jail.
Are you able to estimate how many of the detainees in the Fulton County Jail are represented by the Public Defender's Office?
75 to 80% are represented by our Public Defender's Office, and the remaining 10 to, or another 10 to 12%, I think, anecdotally are represented by GPDC's conflict office or alternative public defender office. And the reason our number has dropped, because it used to be 87, 90%, is because of, and I just assume it's the condition of the jail. There are a lot of fights occurring between the inmates. And as those fights happen, we have to conflict off cases because what it boils down to, it's one client fighting another. And that just creates a conflict that we have to remove ourselves from.
And you mentioned the acronym GPDC. Can you tell us what that means, just for the record?
Georgia Public Defender Council.
Thank you. Now, for public defenders in your office who work with detainees at the Fulton County Jail, how many detainees does any one attorney in your office represent at a given time?
Right now, we just calculated that each of our pre-indictment attorneys has about 75 clients that are incarcerated that they represent. Like I said, that number was much higher up until recently. We were able to bring in a number of new attorneys, so that had a drastic effect on reducing that number.
And you mentioned the pre-indictment unit. What's the pre-indictment unit?
Those are the attorneys that handle cases, just what it says before it's indicted. They deal with the bonds, the preliminary hearings, communications with the families, anything related to a case that we represent a person on that's unindicted. And do you have an estimate of how many attorneys are currently in your pre-indictment unit? In the pre-indictment unit, I think there are 15 attorneys, but the pre-indictment unit is part of what we call the pink unit, the pre-indictment non-complex unit. We have a total of approximately 24 attorneys in that unit altogether. Now, does the Public Defender's Office have a policy for how frequently it visits its detainee clients? The Public Defender's Office as well as GPDC has a policy, and that policy is that all inmates are visited at least every 30 days. That does not necessarily mean that the attorney has to conduct the visit, but it could be an investigator, a social worker, one of the paralegals, just somebody within the office has to set eyes on the client. And the reason we do that is we want to know, A, what's going on with our clients. B, we want to keep developing and strengthening the attorney-client relationship. And C, a lot of times our clients, like I said earlier, get involved in fights. And I don't know if this is just the culture of being an inmate. They don't call us and complain. We find out that they've been hurt when the attorney or someone shows up and sees that they have, 10 or 12 stitches or their arm is in a sling, and we say, well, what happened? And they'll say, oh, I was in a fight. I just got back from Grady or something like that. Typically, the clients don't call and tell us stuff like that.
Is it the Public Defender's Office policy that those monthly visits need to be in-person visits?
Absolutely. And like I said, it goes a long way to develop and strengthen the attorney-client relationship. And there's no substitute for that relationship and that visit taking place in person. While technology is great, there's no substitute for that in-person bonding and experience that happens between an attorney and his client, or that attorney support staff that's working with the client also.
Now, over the last several years, 2020 to now, we obviously went through COVID and had a lot of different restrictions on ability to meet in person. Tell us what the Public Defender's Office has been able to do in terms of, have you been able to go meet with clients in person, even though their family members or other members of the public may not have been able to? Can you just tell the court a little bit about that process?
Even during COVID, our staff met with clients.
In person?
Yes, ma'am.
Now, are there occasions where the Public Defender's Office meets with clients via virtual means?
There are occasions, but generally those occasions are when there's a simple question to be asked or minor information to be passed along, where it's not worth it to spend 3 hours going to the jail, parking, going inside, being checked in, and waiting for the client to be brought down if he is brought down. Sometimes that technology helps out a lot in doing that. When you can do something in 5 or 10 minutes that would take 3 hours. But again, that technology is not a substitute for the relationship and the trust that has to be built between a client and the attorney.
Has your office gone out to affirmatively explore ways in which it can have remote visits with its clients? In other words, certain facilities or programs that it could use?
No, we have not explored any option to do that. We were requested by a county commissioner and the COO to examine and look at a program, I think it was called My Justice Portal. But have we sought out any alternative means of communication for our clients to communicate with their attorneys? No.
I want to move on to exhibits, Judge, and given that we don't have objections to each other's exhibits, are you okay if we just dispense with some of the formalities in terms of entering in exhibits and
fine with me.
Okay, are you okay with that, Your
If you
Honor?
just tender them in bulk, identifying them for the record.
I will. We have an exhibit list, Your Honor, that has petitioners exhibits 1 through 11. And we're going to tender those in bulk, and I will go through those.
Okay, if you
With-
could just list the title identifying 1 through 11, and then I'm going to ask respondent if he has any objections.
Sure.
We'll do it.
Number 1, sure. Number 1 is an August 31st, 2023 email from Veronica Reed, who was Mr. Kenner's executive assistant to Mr. Kenner. Number 2 is a video excerpt of a September 6, 2023 WXIA TV Atlanta news segment. And we also included with that an authentication certification. Number 3 is a September 8th, 2023 letter sent by Mr. Kenner to the sheriff's office, and it has a cover email enclosing it. Number 4 is a September 13th, 2023 Atlanta Journal-Constitution article by Jim Gaines titled "Sending Fulton Inmates Out of State?" Public Defender Seeks to Stop Sheriff. Number 5 is a September 16th, 2023 Atlanta News first segment titled "Commission Chairman Urging for More Fulton County Jail Inmates to be Moved to Other Facilities." And we supplemented that yesterday, Your Honor, with an authentication from the news station. Number 6 is the official video of the September 20th, 2023 Fulton County Board of Commissioners meeting, retrieved from the Fulton County Board of Commissioners website. Number 7 are screenshots of the Fulton County open records request process that Mr. Kenner's office engaged in. And number 8 is 8 through 11, Your Honor, are 4 documents that were received in response to that Open Records Act request from the sheriff's office. Number 8 is a 9/13/23 core civic draft proposal. Number 9 is a 9/23/23 core civic Tallahatchie facility proposal. Number 10 is a core civic Fulton County draft agreement dated 9/7/23. And number 11 is a core civic description of Tallahatchie County Correctional Facility, and it has a date on the bottom corner of May 2023.
Any objection to petitioners 1 through 11?
No, Your Honor.
Admitted without objection.
Thank you. Mr. Kenner, we're going to turn to when you first learned that Sheriff Labatt was considering moving Fulton County Jail detainees out of state. May I approach, Your Honor?
If it's your witness, don't have to ask.
I'm going to hand you what's been previously marked as petitioner exhibit 1.
I'll take a copy. Thank you.
Can you tell us what petitioner exhibit 1 is?
Yes, this is a copy of an email that I received from my executive assistant, Veronica Reed, letting me know that Colonel Curtis Clark wanted to have a communication with me, set up a meeting dealing with the outsourcing of inmates out of state.
And before you received this message, did you have any understanding that the Fulton County Sheriff was exploring whether to send detainees out of state?
This was the first I heard of it.
And this mentions Colonel Clark. Can you tell me who Colonel Clark is, or tell the court who Colonel Clark is?
I believe Colonel Clark is the jail commander. I'm not 100% certain what his position is.
He's a member of Sheriff Labatt's staff.
That's correct.
Okay. Who is Alton Adams?
Alton Adams is the chief operating officer for Fulton County.
And around the same time you received this message from Colonel Clark's office, do you recall having any discussions with Mr. Adams about the same subject, that is out-of-state detainee outsourcing?
I do, I believe.
Objection, Your Honor, to the extent this gets into hearsay.
Ms. Warner?
It's not being offered for the truth of the matter asserted. It's being offered to show its effect on Mr. Kenner and the actions he took based on that information.
With that understanding, the objection's overruled. It wouldn't be just a show of subsequent action. It can't be relied on.
I agree. It's just some of the stuff that borders on relevancy, but we'll
Make that objection as it comes up.
okay, thank you.
Sure. I believe a few days afterwards, we had a Justice Policy Board meeting. And I had an occasion to be present along with Alton Adams and a number of other people. And it was during that time that Alton Adams mentioned the topic of moving inmates out of state.
And did you have any response or talk to Mr. Adams about that concept?
I did. I let Mr. Adams know that was an absolute non-starter, and that was something that we would not take without a fight.
And after that message from Colonel Clark and that discussion you just described with Mr. Adams, did you start then hearing in the general public let me rephrase that question. After you received that that message from Colonel Clark and had this conversation with Mr. Adams, what further information did you receive about the potential of the sheriff transferring detainees outside of state?
Well, I started to look into the reality of that possibly happening, especially when I started hearing Chairman Pitts on the news. I believe it was WXAI. I don't know what number they are on television, but I heard him being interviewed, and he indicated during that interview that a move to out of state was being explored. And there were a number of media videos that I saw, but it led me to believe that something was going to happen, and it was rather imminent. I believe I drafted a letter to the sheriff, letting him know what my position would be, and that I opposed any move out of state. And I believe it was about 2 or 3 days later that we filed a mandamus, writ of mandamus.
We're going to turn to that letter in a minute. Your Honor, we have submitted links for these videos, but given that Mr. Kenner's just kind of explained what the effect was on him, unless Your Honor wants to hear them, we can just submit them to you for your consideration instead of playing them in open court.
All right. I think they've been tendered for the record. So if I need to take this under advisement and view those, I have that ability. But as it stands now, he's describing their content. That's sufficient for me. And I don't see us having reached really any area of contention yet. So I would say that I don't see the need to do that. Any thoughts there, Mr. Dreyer?
No, that's fine, Your Honor.
Okay.
Mr. Kenner, you mentioned a letter you wrote to the sheriff. I'm going to hand you Petitioner Exhibit 3.
Thank you.
Thank you.
Can you tell us what Exhibit 3 is, Mr. Kenner?
This is a copy of a letter that I sent to the sheriff on September 8th, 2023.
Why'd you send this letter to the sheriff?
I wanted the sheriff to know that that I had become aware of the imminent possibility of transporting some of our inmates out of state. I wanted him to know what effect that would have on my attorneys and what my office does. We have the folks that are incarcerated, not only do their attorneys visit with them, but we have investigators that routinely visit with our clients that review discovery. We have social workers that visit with them. We have paralegals that visit with them, and that's all part of developing and strengthening that attorney-client relationship. That is something that has to take place in person. In my opinion, there's a television camera can't substitute for that.
Now, you note in this letter on the first sentence of the second paragraph, while I certainly understand and appreciate the need to move detainees out of the Rice Street Jail for their own well-being, it's our position that they must remain within the state of Georgia. Focusing on the first half of that, the well-being, has the public defender's office, you mentioned having clients who were injured in the Rice Street Jail, but have any of your clients died while they were in the Rice Street Jail?
I think at least 10 have died while in the Rice Street Jail. It may be as high as 14, but I know at least 10.
And in that latter half where you write, it's our position that they must remain within the state of Georgia. Tell us what that position is and what it's based on, Mr. Kenner.
That position is based on OCGA 4244, which says that if a sheriff's jail becomes unsafe, the sheriff can look to an adjoining county to possibly move inmates or other counties to keep our clients within the state of Georgia.
Now, in addition to the importance of face-to-face visits and some of the other things that you've already explained to the court, are there some logistical challenges that your clients and your office could face if detainees were outside the state of Georgia?
Absolutely. If they're transported outside of the state of Georgia, what would immediately have to happen is I go back to the BOC and ask for money because at that point, my investigators and attorneys would have to travel up to 4 hours to have a meeting with the client at an out-of-state facility. They would have to provide the transportation. They would have to provide room and board for them to stay overnight. I think it would be not realistic to ask them to drive 8 hours in a day in addition to meeting with the client. Even if they are within the state of Georgia, that's still going to be a challenge. But going further than the state of Georgia is just more of a headache.
When your clients get called into court and have, for example, a trial calendar or some appearance that they have to appear for, would that process be affected by them being out of state at all?
Yes, it would be. It would be next to impossible to communicate with the client. And sometimes the attorneys, because of that close relationship they've developed with meeting with their clients, they have to help the client make tough decisions on whether to accept a plea or whether a sentence is reasonable. And all of that trust from the attorney is born from the in-person intimate relationship that's able to happen when they're able to see their client within a reasonable time from going from the office to a facility that's incarcerating them.
Now, you as part of what you discussed about clients fighting in jail and getting conflicted off of things, when public defender clients have, for example, a fight in jail, do they face like a charge or an infraction, or do they face some kind of legal consequence as a result of that?
Absolutely. As of late, they've been being charged. To the extent that I know that they've had a fight, they're being charged.
And who charges them?
Either the solicitor's office or the district attorney's office. All of the cases that I know that there have been charges are from the district attorney's office, though.
And that's the district attorney's office for Fulton County?
Fulton County. Look, and another concern of mine is if our clients are moved out of state, they're still incarcerated inmates. They're still are going to, things happen in jail. They're still going to fight. A concern that I have is now the county has helped create multi-state offenders, because I would expect that they would probably be charged in Mississippi too, depending on the severity of the fight. That creates, a problem with how do we represent our out-of-state client? We can't.
You also wrote in your letter, I believe it's the second page, it's imperative that we see our clients, and excuse me, I'm reading the wrong paragraph. There are alternative means to reduce the jail populations, which we are actively pursuing with the district attorney's office through a joint effort aimed at obtaining consent bids, diversion, and case resolutions. Explain to the court what efforts your office has been engaged in to reduce the population at Fulton County Jail.
Sure, for about the last 5 to 6 weeks, at least 3 days a week for 6 to 7 hours per those days, the district attorney's office and my office have basically put senior attorneys in a room and had them review cases, review bonds, and come up with ways to get folks released from jail. And as a result of that collaboration, I think the number is up to between 400 and 450 people that have been released from jail or had their bond modified significantly so that they could be released, or their case has been disposed of or dismissed altogether.
And that's just in the last 5 to 6 weeks, you said?
That's correct.
And at the end of your letter, Mr. Kenner, you wrote, in the event we're unable to reach consensus on this point, we're prepared to pursue legal action. Did you receive a response to your letter from the sheriff's office?
I received a response from the sheriff's office. It wasn't from the sheriff. It was from the sheriff's legal counsel, Ms. Joyner. And I think it was on a Saturday when I received that response. So.
And did that response address the points you raised about the sheriff not having authority to move, in your view, detainees outside the state of Georgia?
I would have to look at it again. I don't remember exactly what it said.
I thought I had a copy of it. 1 second, please. I'll come back to that.
My recollection of it, I think, is that while the letter indicated the sheriff's office looked to still continue to work with us, I don't recall that there was a statement or anything to suggest that the sheriff's department was not still considering moving inmates out of state. But like I said, to tell you with 100% accuracy, I would need to review the letter again.
And after you sent that September 8th letter and received that response, what did you do? What did you do next to try to address the potential issues you saw that would arise from transferring detainees out of state?
I think at that point, I communicated with my appellate supervisor and had him draft the first go around of a petition for a writ of mandamus.
And you had your office filed that petition for writ of mandamus, right?
That's correct.
And after that, you engage my office, right?
That's correct.
After you submitted that, filed that petition, did you continue to see information in the public about the sheriff's actions that would go towards moving inmates out of state?
I did. There were other news clips or blurbs on the news about it. Also, as part of having my staff start to prepare the petition for writ of mandamus, I had the person that drafted the initial petition also conduct an open records request. And
We're going to turn to that in just a moment. And Your Honor, we had 2 additional exhibits that were on our list that I already read off, 4 and 5, which were, again, links for news coverage that Mr. Kenner just testified about. I will forego playing those in open court in light of his testimony. Did you attend the Fulton County Board of Commissioners meeting on September 20th, 2023?
I did.
You attended in person?
I did.
And was that meeting open to the public?
It was.
Did you address the Board of Commissioners?
I did.
What did you address the board about?
During the public comment, I let the Board of Commissioners know my position on moving and potentially paying for our clients to be moved out of state. I let them know that I was totally against it. I let them know the effect that would have on my attorneys and my office's ability to represent our clients. I also, other folks from my office spoke to about the impact a move like that would have on our ability to do our job and represent our clients effectively. Other folks within my office, I had we call them ASMs, the alternative sentencing mitigation specialists, social workers.
Mm-hmm.
I had a supervisor speak of the impact that move would have on what they do. I had an investigator speak on the impact the move would have on them being able to communicate and reach the clients. I also had an attorney supervisor speak to talk about the impact a move like that would have at that meeting.
And did Sheriff Labatt appear at that meeting as well?
He did.
Did Sheriff Labatt make a presentation to the Board of Commissioners about sending inmates out of state?
He did.
And were you present for his whole presentation?
I was.
Your Honor, we've marked as Exhibit 5 the official video from the Fulton County Board of Commissioners meeting. And we want to tender that specifically for the admissions that come from the sheriff.
I
I'm
thought you
gonna,
said 4 and 5 were the news items.
sorry. Maybe I wrote that number down. I said the number wrong. It's 6.
It's already been tendered.
Would you please describe for the court what you learned from the sheriff's presentation about his plan to move inmates, or excuse me, to move detainees outside the state of Georgia from that meeting?
I think I learned that he had already visited the out-of-state facility. And I learned how serious he was on moving our clients out of state.
At that meeting, did the sheriff or the sheriff's office present financial information to the board about what the cost of housing detainees outside of state in that Tallahatchie, Mississippi facility would cost?
They did, and I think those numbers were somewhere between, it was a graduated number from 1 to 500 inmates, and then from 500 to 1,000. I think it was more than $1 million for the first up to 500, and then I think it was around 3 million up to 1,000. The exact numbers I don't recall, but I will say it was a lot of money.
And when you say 1 million or 3 million, was that per month, per year?
I think that was per month.
Now, we talked a minute ago about you mentioned the Open Records Act request. Show you what's been marked as petitioner's exhibit 7. These are screenshots, so the writing is a little bit small. I put a tab on the page that I'd like you to turn to, which lists the 3 requests that were made in the Open Records Act. They're small. I have
Yes.
them blown up over here, so I'm happy to read them if you are having trouble, because I had a little bit of trouble.
If you could.
With your permission, Your Honor, can I read them to save Mr. Kenner's eyes?
I'm sorry, I have to re-ask.
That's okay. I was asking if it was okay, instead of having Mr. Kenner read these 3, because I have them blown up over here, if I could just do that, and then I'm going to ask him some questions about the documents.
It's part of the record.
Okay. Number 1, it looks like there are 3 requests listed in that box that says Open Records Request on top. You see that?
Yes.
Okay. Number 1 reads, for any facility outside Georgia to which the sheriff contemplates transferring pretrial detainees, please provide any materials in your possession or control describing available bed space there for men and women detainees, facilities and programs offering medical, dental, and mental health care and pharmacy services, equipment and technology that will be actively available for video or other conferencing between detainees and their attorneys and family members, safety statistics, including reports of serious injury or death among inmates, and protocols, plans, and means of transportation by which detainees will be brought back to Fulton County for court proceedings. Number 2, please provide in their entirety any contracts, agreements, proposed agreements, and memoranda of understanding between, on the one hand, the sheriff's office and/or Fulton County, Georgia, and on the other hand, any out-of-state entity relating to the transfer of Fulton County detainees outside of Georgia. And the third and final request, please provide all documents, email communications, recorded presentations, or other materials relating to the sheriff's criteria for determining which pretrial detainees to transfer out of state. Do you see that?
Yes.
And the response that came back to this Open Records Act request. Do you recall how many documents the office received or what those documents
Sure.
were?
I think we received 4 documents.
I'm going to give you those 4 documents, which have been pre-marked as exhibit 8, 9, 10, and 11. If you look in the bottom corner, you will see the exhibit number. Eight. Nine. It looks like I unfortunately only have 1 copy of 10, which I gave to the witness. I will have him.
She's marked them. Does that work?
I'm familiar. Unfortunately, I did not make enough copies of 10. I only had 1. and I
We're
gave it to
fine,
the
we got
witness,
it.
but,
We got it. Yeah.
And here's 11. Mr. Kenner, are those 4 documents I've just given you the ones that you received in response to the Open Records Act request?
Yes.
Let's look at the first one, which is 8. What does number 8 appear to be to you?
It appears to be a descriptive sheet of the Tallahatchie County Correctional Facility in Tutwiler, Mississippi,
And what's the date on that number 8?
May 2023.
And when you say description, what, just briefly, type of information is included in number 8?
It's telling the size of the facility, the number of beds, the accreditation the facility has.
And if we look at just collectively numbers 9 and 10, do those appear to be similar documents to number 8 in terms of the descriptive information that they provide about the Tallahatchie County Correctional Facility?
Yes.
Mr. Kenner, I've given you what was marked as exhibit 10, the one I only had 1 copy of. What is number 10?
Number 10 is, it looks like a proposed contract for the signature of the sheriff, the facility in Mississippi, and the county manager of Fulton County.
Now, if you look at number 10 on page 2, there's a paragraph entitled Delivery of Pretrial Detainees. Do you see that?
Yes.
Can you read that first sentence of the second paragraph?
The contractor reserves the right to refuse or remove any pretrial detainee from the facility if the contractor determines it is in the best interest of the contractor.
What effect would a contractor refusing to move a detainee have on your office's ability to represent that detainee?
Can't get them to court or won't get them to court.
On page 3, there's a section titled discipline. It has two very short paragraphs. Will you please read that second paragraph?
Pretrial detainees who have violated the contractor's rules and regulations will be subject to the same disciplinary rules and regulations as any other pretrial detainee housed by the facility. However, nothing contained herein shall be construed to authorize or permit the imposition of a type of discipline prohibited by state and federal laws and regulations applicable to the county or the state of Mississippi.
And what effect would the disciplinary action described in that paragraph have on on the public defender's office detainee clients?
It would cause them to become multi-state offenders.
And for those of us who don't practice criminal law on a regular basis, what is the effect of becoming a multi-state offender?
Well, it's certainly not good in any manner, but instead of having a criminal record just in the state of Georgia, then you'll have one in two different states. Having one in one state is bad enough. Having more than one in more than one state is even worse.
And then on page 4, there's a section titled transportation. Can you read that second sentence of that section, please?
The contractor shall then provide one round trip transport per month between the Tallahatchie County Detention Facility and the Fulton County Jail, utilizing contractor's 30-seat transport bus.
And based on your experience with the volume and number of interactions that your office has with its detainee clients every month, what effect would one transport of 30 detainees per month have on your office's ability to represent its clients?
That would mean there would be a number of detainees that would not have in-person contact with their attorney or other individuals in our office that assist those attorneys.
And if you look at the last page, there are 2 signature lines. Can you read who the signature lines are for?
Sheriff Patrick Labat and Dick Anderson, the county manager of Fulton County, Georgia.
Thank you, Mr. Kenny. You can put those aside. We're done with those. Mr. Kenner, are you asking this court to keep detainees inside the Fulton County Jail on Rice Street?
No,
What are you asking the sheriff? What are you asking the court to do with this writ of mandamus?
I'm asking the court to require the sheriff of Fulton County to find other facilities within the state of Georgia to house and safely maintain our clients. And I don't do much civil work. In fact, I don't do any civil work, but it may be that the sheriff needs to file a mandamus against his fellow sheriffs to force them to safely detain some of our clients.
And do you have any indication that the sheriff has sought court intervention to get other sheriffs within the state of Georgia to accept inmates from the Fulton County Jail?
I'm not aware of anything he's done.
I don't have any further questions, Your Honor.
All right. Any cross-examination?
Thank you, Your Honor. Mr. Kenner, is Mr. Kenner good, or is there a title I should be using?
You can call me Maurice if you want. Mr. Kenner's fine.
Thank you. I'll go with Mr. Kenner though. Thanks. You mentioned the Board of Commissioners meeting for Fulton County, where there was discussion about transferring detained individuals to Folkestone or Mississippi potentially, right?
Right.
And was that meeting on about September 20th, 2023?
That's correct.
Okay, great. And is fair characterization of that meeting that the majority of time was spent on the Geo Folkestone facility as opposed to the Mississippi facility?
I'm not 100% certain.
Wasn't it? I'm sorry, go
There
ahead.
was discussion of both facilities. I didn't measure the quantity on each facility.
You don't have an impression of whether more time was spent on Folkestone as opposed to Mississippi?
I don't recall.
And as part of that presentation, the sheriff's office did mention that they weren't very far along with the Mississippi facility as far as any deal with them, right?
I recall the sheriff saying that he had visited that facility. I don't specifically recall him saying that. I'm not saying that he did not say that.
The Exhibit 10 is the contract. You have a copy of that, right?
I do.
And this contract is unsigned, right?
That's correct.
Okay. In your experience, contracts are negotiated over a period of time and the terms change before they're finalized, right?
They do.
Right. And presumably there would be a period of negotiation related to this contract, right?
I don't know that what version of the contract that this is, since this is the only one we received. I would assume that it's close to the very end of contract negotiations,
But what do you base that on, that presumption?
because this is the only one that we got.
Could this have just been the initial sample contract that this facility provided?
It could have been.
Okay, and if you look on page 7, paragraph 27, where it says governing law, do you see that it says the laws of the state of Tennessee shall govern this matter?
Yes, I see that.
Okay. And to your knowledge, has Fulton County ever entered a contract that had a Tennessee choice of law provision?
I don't know.
Your office does contracts, right?
Occasionally we do.
And you have Georgia choice of law in those, correct?
I would assume so.
You probably have venue in Fulton County too, don't you?
Probably.
And then when you mention the transportation provisions in this contract, are you aware that there would also be a contract from an affiliated company related to transportation that would be signed at the same time this one would be signed, if it was ever signed?
I'm not aware of that.
Are you aware of how long it takes to drive to Folkestone, Georgia?
I think it's about 3.5 hours, between 3.5, 4 hours.
When we've looked, it's been a little bit under 4 hours, about 4 hours and 45 minutes. I guess it could be that as well, right?
Depending on how fast you drive.
I mean, it takes me about 4 hours to get to Savannah, give or take from here, right?
Takes me about 5.
Fair enough. Folkestone's much further south than Savannah and close to Jacksonville, right?
I think so.
Okay, and if someone were to go to Folkestone, it'd probably be a little quicker to fly to Jacksonville and drive over, right?
Possibly.
And presumably, folks from your office would be able to fly to Mississippi and drive too, right?
Probably not. That would cost additional money.
Okay. Have you asked the Board of Commissioners for funding for that? And you haven't asked them because there's no contract and there's no imminent transfer, right?
Well, there hasn't been any transfer.
And there's no contract either, right? Signed contract.
Not that I'm aware of.
You mentioned
But-
the My
but-
Justice portal, and I'll
Can I be clear on something?
sure.
We're not happy that our clients are being moved from Fulton County to any facility. But I recognize that that facility is dangerous, and the inmates there need to be taken care of. Their welfare needs to be taken care of. Traveling 3 hours in-state, 4 hours in-state is still going to be a big headache for us. But it's something that we will do with the support of our Board of Commissioners.
When you originally filed your mandamus petition, though, you were trying to block transfers of detained individuals to Folkestone, though, right?
Never.
That wasn't in there?
If you want to respond to the objection. on
Um,
relevance.
I'm sorry, Your Honor. Yes. He is that, Your Honor, it's hard with Your Honor's statement about public policy and intent, but specifically related to the burden on the public defender's office between Folkestone and Mississippi is a very minor one. This is related to that.
All right, I'll allow you to, I'll overrule the objection, allow you to establish the record on that point.
Thank you, Your Honor. You're not aware that the original petition filed in this case was also seeking to prohibit the transfer of detained individuals from Fulton to Folkestone, Georgia?
Our opposition was across state lines. Anywhere within the state of Georgia, the statute provides in such a way that we have to deal with it.
I'm gonna go ahead and, if it's okay, Your Honor, hand out our exhibits. There's one I want to bring to the court's attention, to the witness's attention.
Thank you.
Mr. Kenner, you mentioned this My Justice portal once, but isn't it true that at least in one email from Luana Walsh at your office, that one of the advantages represented by Ms. Walsh was the ability, would eliminate the need to go to jail?
One of her emails may have said that, but if you recall my earlier testimony, a piece of technology like that would be used for quick items, to pass on a quick bit of information, to receive or deliver information that would not necessarily require us to tie up several hours of attorney time or investigator time. It's not a substitute for that in-person visit. It's a complement to an in-person visit.
But it does allow you to communicate with clients.
It
right?
could, yes.
Are you aware of a subsequent meeting with Ms. Walsh and the sheriff's office where she also verbally said that the My Justice portal could replace in-person visitation?
In some circumstances, it could. And again, it comes back to what I've just said. I don't think anybody that we represent would want to go to trial or enter a plea based on a relationship with a television attorney. There still has to be that relationship established between the client and the attorney. The television can't substitute for that.
It's not television though, is it?
It's a form of technology.
Well, I mean, we have court hearings on Zoom, right?
Yes,
Okay. And
That's-
I
that's-
usually get a good result out of those. I mean, I'm assuming that the judges can manage that correctly, right?
I would think so.
Do you recall September 26th, 2023 Zoom meeting with the GEO group in Folkestone, Georgia?
I do.
And you were participating in that, right?
Right.
There was an opportunity for you to ask questions on that call, right?
There was.
Okay. But you didn't ask any questions on that call, correct?
That's correct. And the reason I didn't, because I knew we had pending litigation.
But you did ask to meet with GEO group privately, right?
I did.
Even though there was pending litigation?
To answer some of the questions that we had, yes. None of my questions related to litigation, but I was of the opinion I didn't want to give my opponent any indication of what I was thinking on any subject.
Who's your opponent?
It would have been the sheriff's office. That's who I'm seeking a mandamus against.
Yeah, but I mean, we're all trying to keep prisoners in Fulton County safe, right?
Totally agree. Safe
that-
in Georgia.
I mean, that takes cooperation, right?
It does.
Okay, and did you meet or request to meet with the sheriff's office before you sent the letter, which we've seen earlier, objecting to the transfer of prisoners?
I don't think I did.
Okay. Did you request to meet afterwards?
I don't think I did.
Did you do any investigation to determine what other options there were to house people currently detained in Fulton County?
Did I do a personal investigation?
Yes.
Other than reading the statute and saw that the sheriff would be required to send inmates to other facilities within the state? No.
Did you or anyone in your office do any investigation to see what capacity was available for at different county jails for detained individuals in Fulton County to be moved to?
No, but do you honestly think that they would give that information to me as the public defender?
I mean, a lot of it's available online, isn't it?
I don't know.
Yeah, because y'all never looked, right?
I didn't know.
My last question is, has your office requested a speedy trial in every case?
Except when it's strategically not feasible to do, generally we have. And that discretion is ultimately left to the attorneys.
But you haven't requested a speedy trial in every case, right?
Not in every case, no.
No further questions. Thank you.
Thank you.
Any redirects solely on those points?
Questions, Your Honor. Mr. Kenner, does the Public Defender's Office have authority to move detainees from one facility to another?
No.
And Mr. Dryer asked you whether, after you wrote this September 8th letter, you asked to meet with the sheriff. Do you recall that?
I don't.
Do you have a copy of this September 8th letter in front of you? It should say Exhibit 3 on the bottom from my questioning of you earlier.
September 8th.
That's the one.
Okay.
Turn to the second page, the last paragraph, please. Can you read that last paragraph into the record?
For all the above stated reasons, I reiterate our strong objection to the proposed moves. In the event that we are unable to reach consensus on this point, we are prepared to pursue legal action. Please let me know how we can reach a resolution to this very real concern.
And in response to that request to how you all could reach a resolution, did the sheriff's office offer to meet with you?
I don't recall that they did, but I don't fully recall what the letter Ms. Joyner sent.
And as we, after this petition was filed, do you recall that on your behalf, we asked the sheriff's office whether they would agree not to transfer any detainees out of state while we attempted to resolve this petition?
I do.
And what was that response?
No.
I don't have any further questions, Your Honor.
One, Your Honor, so.
All right, just one.
Thank you, Your Honor. Mr. Kenner, will you look at Exhibit G in that notebook next to you and just the very last sentence?
Thank you again for your thoughtfulness, and I hope that you contact me to work through this matter. Best, Amelia.
And that was Ms. Joyner asking you to contact her office to work through this matter. Is that correct?
That appears to be.
Thank you. No further questions.
All right, and just to complete the record on that point, Mr. Dreyer, why don't you describe response exhibits A through G, and we'll see if there's an objection to their tendering and admittance at this point.
Thank you, Your Honor. Respondents Exhibit A is a memo dated February 9th, 2023 from Sheriff Patrick Labatt to all Georgia sheriffs. Respondents Exhibit B is a September 20th, 2022 letter from Fulton County Sheriff Pat Labatt to the Acting Director of the National Institute of Corrections. Respondents Exhibit C is a August 22nd, 2023 email from Luana Walsh at the Public Defender's Office to Amelia Joyner at the Sheriff's Office. Respondents Exhibit D is a July 25th, 2023 email from Luana Walsh at the Public Defender's Office to Amelia Joyner at the Sheriff's Office, copying Public Defender Maurice Kenner. Exhibit E is the public information entitled Weekly Status Report, September 8th through September 14th, 2023, with stats on detained individuals and location from the Sheriff's Office. Respondents Exhibit F is a 2-page memo explaining regarding jail capacity generally, outsourcing efforts, and the capacity at various facilities. And Respondents Exhibit G is a September 9th, 2023 email from Amelia Joyner to Mr. Kenner and Ms. Walsh at the Public Defender's Office.
Any objection from the petitioner to respondents exhibits A through G?
No objection.
All right, admitted without objection. Mr. Kenner, one question before I let you go from the court. It's my understanding of Uniform Superior Court Rule 9.1 and 2 that while many of the criminal proceedings can be conducted by Zoom and virtually, criminal trials cannot be absent a defendant's consent. Would you have any idea of what your office, how they would handle a request to conduct a criminal trial completely remotely, and whether that would be something that's just decided on a case-by-case basis, or do you think your office would impose a policy as it relates to that?
We would impose a policy opposing.
Opposing what? Opposing what exactly?
Any trial being conducted by Zoom.
And why is that?
I think it's important for the attorney and the client to be able to see, read, and feel the testimony and the vibes of any potential client or potential witness that may be brought against them. I mean, a Zoom video there are a lot of intangibles that you just, you can't get the feel through a television screen. You have to be present to truly read the demeanor of a witness and feel the demeanor of a witness and the tenor of a trial. You can't do that through Zoom.
All right, counsel, anyone want to follow up on just that issue itself, by itself? All right, Mr. Dryer.
No, Your Honor.
Okay, can this witness be excused, Ms. Warner?
Yes.
Any objection, Mr. Dryer?
I agree.
Mr. Dryer, any objection to excusing this witness?
No, Your
Okay,
Honor.
thank you, Mr.
Thank
Kenner.
you.
Petitioner may call us next witness.
May I please ask for a brief restroom break before we call the next witness? Or are you gonna allow us to have one?
I was under the assumption you only had one witness.
No, I only have one witness. Yes, I'm
Right.
sorry. I was thinking about his. I
No, no.
apologize.
Petitioner, have another witness.
I have no other witnesses.
All right, petitioner rests.
I rest.
Okay, why don't we take a lunch break and we'll come back at 1 o'clock.
Perfect.
All
Thank you. I was 2 steps ahead on that one.
We're off the record, but to both parties, Ms. Smith is going to need stickered exhibits for the record. So you
I
can
have
get those for her.
stickers that I can add. So I'll
And you
fix
can
those
use
on the lunch break.
these as well if you need extra copies.
Your Honor, the actual image of the sticker, is that okay?
Okay, I'll leave it, just run it by her.
Thank you. I don't need this. Who is this?
It was in that binder.
Thank you. I'm gonna take some of my stuff, not all of it though.
Sorry. Go ahead, go ahead. No, I'm not, yeah.
I'm gonna
Turning back around.
Jaime, will you take these with us? Right?
I am leaving this stuff here because I got my team.
Sure. Yeah, you want me to take the?
Thank you.
You're welcome.
to Department of Communications as office manager, moving to the Fulton County Fire Department as chief of staff, and to the county manager's office as assistant to the chief operating officer before coming here about 2 years ago in the sheriff's office.
Thank you for your service.
Thank you.
And what are your duties with the Fulton Sheriff's Office?
I am responsible, directly oversee the HR, IT, finance, special projects, minor things. I'm basically the right hand to the sheriff.
What is special projects?
Special projects entails basically any new initiative or ongoing big projects that we take on as an organization.
And what's your involvement with the issues here in this lawsuit today?
One of the things that I've assisted in working on is our possible outsourcing to other facilities and reviewing plans, helping to find solutions to relieve the overcrowding at the jail.
Okay. And will you explain what the issues are with overcrowding, what issues that creates?
Well, right now, our number one priority in the sheriff's office is the safety of those within our custody. We're always trying to find, we're constantly looking for any type of measure to relieve the overcrowding, to produce, to allow for a safer environment. That's the biggest challenge. Our staff, our physical plant has deteriorated, in a bad way. When it was built, it was already overcrowded, and then the stress from the number of inmates has further, torn the building up.
Are you talking about one facility in particular?
Well, the main jail in particular, but we've had problems with our annexes, which we were, and as an example, we have a South Annex that it was in very similar condition to Rice Street. We were, like I mentioned before, we look for any types of ways to limit the population at Rice Street. So, of course, Fulton County is engaged in outsourcing, looking for other opportunities to house inmates. One, that's been probably the most heard about is our use of the Atlanta City Detention Center. And so that facility is much newer than ours and much better condition. So the South Annex, which experienced a lot of the physical stressors as Rice Street, we, through an agreement with the city of Atlanta, which took some time and which has been in place for years, because this problem, of course, has been an issue since I've been with Fulton County for, since '95. And so there's been off and on talks to try and get another facility to help alleviate the stress of the population. So recently, we gained some more traction with the sheriff, the current sheriff, upon his election. He previously was the chief of the Atlanta City Corrections. So he was intimately familiar with the Atlanta City Detention Center. So with that help, it gained a little bit more traction, and we were able to engage in some fruitful talk with the city. And in doing that, although it took some time, we were able to move the population from the South Annex to ACDC. And in doing so, it allowed us to go into the South Annex and completely rehab the facility. We used that as an opportunity to start trying to get some rehab efforts at Rice Street. And so we moved a portion of the population from Rice Street to the South Annex upon its completion to free up space to do basically an overhaul in parts of that building. But the problem is we have so much of a population, it's just hard to move people and rehab the facility at the same time. So we've engaged in, our population is is a key stressor. So it's that's taken a lot of our time recently.
Will you describe the timeline of when detained individuals in Fulton were first moved to ACDC and then the rehabilitation efforts that have taken place?
So I believe we began talk in the summer of 2022 with the city of Atlanta. We came to an agreement towards the end of that summer, and I know that the sheriff and the chairman of the Board of Commissioners signed the agreement on or about December 8th. No, it's December 5th. The mayor signed it on December 8th, but when he signed it, there was a stipulation that was attached to it from the city council that had a 90-day moratorium. And so it delayed, and that was so that they can do a population study. We then, after that was completed, we then transported all of those inmates from the South Annex to ACDC. And
Who was being housed in the South Annex at that time?
at that time it was all women.
Okay. And what other parameters did the city of Atlanta put on the use of ACDC?
Well, that was one of the first. The others, it pretty much involved classification. So the agreement called for up to 700 inmates. It's been extremely hard to get there for two reasons. One is staffing. All law enforcement partners, whether they be corrections or any type of law enforcement, is competing for the same staffing in the metro area. So everybody is understaffed. So one of the stipulations of taking ACDC is that we have to staff the facility. So we did, with the help of the Board of Commissioners, we were able to ramp up our hiring and do better on our retention. We became the highest level entry law enforcement agency in the state.
Highest level entry, what?
All detention and deputies are the highest paid upon entry. So there was a lot of efforts put involved. Because of those, our staffing levels increased, which allowed us to staff the facility to a certain point. And so that's one of the reasons why we can only go to a certain level. The other reason, and which is a big reason, is the classification. We have to submit all of our names to ACDC for them to vet, and they approve who comes over. That takes so much time that, let's just say, and this is a common occurrence, we'll send 200 sheets over in a week. They may approve 50. Of those 50, 15 or so might have already been released. And so that's a common occurrence. And then some of the other inmates who are already housed at ACDC, some of them may have been released as well. So the number stays somewhere, around 400 to 450. It depends. But it's difficult to staff much higher than that for those two reasons. One, staffing. Two, the acceptance of inmates from ACDC.
And then will you discuss, I think you mentioned the rehabilitation of the facilities at South Annex, the timeline and what was done there?
Let me jump in there, and I want to flesh that out. Are there certain inmates or classifications that ACDC is categorically denying?
Yes.
And can you describe that?
I can't describe it completely, but I know the more, and this is layman's term because I'm not into law, but the more dangerous they are, they're not going to accept those.
And that's purely discretionary on their part?
I'm not sure if it's discretionary or if it's part of the agreement, but yes, it is. It's not our choosing.
All right. And along those lines, any idea of the percentage of the current population that would be detained at this time on violent versus nonviolent charges?
I can't give you that exactly. I can tell you, for instance, we have close to 500 murderers just alone, and we have many more when it comes to aggravated assault and other crimes that are that are close, that you wouldn't want people on the street. They wouldn't be on the street for any reason.
And what you're saying is that ACDC is not accepting anyone charged with murder at a minimum, because that's about as
Correct.
serious violently as it gets.
Yes.
Mr. Dyer.
Well, thank you, Your Honor. And when you submit the names sheet for each inmate, is that what you described?
Yes.
To the city of Atlanta, do you get any feedback on why some people are rejected?
No, we get a list
A list
of those who are accepted.
Thank you. Will you go through the rehabilitation of the, would you go through the rehabilitation of the South Annex timeline and what it's used for?
Okay, so originally when we envisioned shuttering the South Annex because of the conditions. However, the population, the way it is, we were, like I said, we attempted to find any solution to relieve the overcrowding, to make it safe, because that's the bottom line. But since it was empty and we weren't able to get as many people initially as we were hoping for and that we were trying for, we began rehabbing it in it was late in 2022. I can't give you an exact date, but it was late in 2022. It took several months. Now, I will say this though, although it took several months, it was so much easier and faster than what we could ever do at Rice Street because it was completely empty. So we were able to go in there, have multiple contractors doing different things, whether it be plumbing, electrical, whatever, everybody coming in at the same time. So it was beneficial. So when we first opened it, we were, of course, and like I said, everything goes back to the safety. The initial reason for opening it was sending not just people who are violent, but people who have been violent since they have been incarcerated. So if you attacked another inmate, you were going to go to South Annex. If you attacked a staff member, you're going to South Annex.
I've never done that.
And South Annex provides a little bit more isolation so that we can better control the environment for those inmates. So it kept them safe, but it also kept others safe. So that was the initial goal. But in an effort to rehab Rice Street, we ended up emptying a pod and sending those people to the rehabilitative facility. It was better for them because it was, it had been rehabbed somewhat. But then it allowed us an opportunity to rehab a portion. And right now they're working on 1 North at Rice Street. In the next, I think, week or two, I expect it to be completed. Once that's completed, we'll be able to move another housing unit over, and then we can start rehabbing that. So that all is part of what we call a bridging plan. So in April, I believe April 19th or something like that, the Board of Commissioners, they began helping us through emergency funding. And we hired a company, a logistical company, an emergency management company called Emergency Management, EMSI, Emergency Management Systems, Emergency Management Systems Incorporated.
International?
Yes, international, that's it. So we hired them, they're logistical experts, help with moves, just anything maintenance-wise. They helped us develop what we call a maintenance splits and a bridging plan. And it's a plan that allowed them to rehab a portion of the facility and have the next step in line. With the initial development of that plan, we thought it was going to take about 30 days for each housing unit, but it was closer to 90 days based on, of course, everybody knows supply chain issues, as well as, other unanticipated factors. You know, some work took a little bit longer than expected. It was just a few different issues, but it's taken a little bit longer than expected, but it's working. So we've taken all kind of efforts to try and reduce the population to help in that regard. So even in those efforts, you know, what was born of some of that is what a new unit that the sheriff created called our inmate advocacy unit. So with our inmate advocacy unit, it was charged with helping to reduce the population as much as possible. So through that, he also entered into partnerships, specifically with the Solicitor General and the DA. So going back to the inmate advocacy unit first, that unit has been charged with reviewing every case we have in the jail to find out what we can do to move that along, whether that is working with the DA on consent bonds, working with the Solicitor General on very similar activities, working with the Solicitor General to create what we have. We have a PAD, Policing Alternative Diversion, I believe that's what it stands for. We actually just recently instituted that in our intake center at the jail, so we can try and divert people to programs and other opportunities. So that same unit has reviewed, they were established 4 to 5 months ago. I can't tell you exactly when, but in that short time, they've reviewed 7,000 plus cases, and they've aided in the release of 1,400 cases. So of course, that's with our partners when we're dealing with the DA, the Solicitor General, the judges, whether it be on the state, superior, whatever level, working with their case managers and their calendar clerks, that people from our inmate advocacy unit are calling when they see things that are stalled or they haven't been heard from, and pushing that on behalf of those inmates. So whatever avenue that we've had to try and reduce this population, we've been pushing.
And the folks that are being released in this, what type of charges have they been facing?
Well, the ones who are released, of course, if they're going to be released, that means it's not going to be one of, and, you know, like I said, I'm not a lawyer, so I can't tell you the specific terms, but I know they're not going to be no kind of violent offenders or anything. There's going to be people who, for instance, I know some of them, the only reason that they may be there is the bond. So we've been working with bond amounts with, with the DA's office and the Solicitor General. So I can't tell you exactly who we're releasing. That's not my avenue, but I know that they are eligible, because not everybody's eligible for some of that work.
So then if there's a large number of nonviolent people that have been released, what does that leave us within the general population of the detained individuals now?
I'm sorry.
Yeah, if those efforts, those partnerships,
Yes,
have led to the release of, did you say 1,200?
they've aided in the release of at least 1,400 people.
1,400 people that are largely nonviolent. Was that your testimony?
Yes, correct.
Okay, then what's left? And
well, the vast majority of those people that are there for something very serious. The population that's there, not all of them, but there is a large population of violent offenders. And for us, it's an extreme concern, because when you're overpopulated, and of course everybody knows about some of the locking mechanisms or some of the beds that we were using that we have cut down, tremendously. The portable bunks, but we've looked, we've tried to spread out the population as much as possible, which led to some of our efforts to outsource. For instance, the sheriff, he contacted, I think we have 159, 158, I don't know how many counties in Georgia, but he sent a message to every sheriff's office in the state, requesting assistance, trying to alleviate our population. So he contacted everybody. First, he did this, prior to his letter, he did this personally, contacting most of the metro area ones, but then he did it officially by sending it to every sheriff in Georgia. We got few responses, and we're utilizing everyone that responded. We have people who are in, like Oconee County or Forsyth County, where we have contracts with so that we can outsource there. We have people who are in Cobb County, where we have, a substantial number of people there. We also did receive information from other counties who said, we have space, but we don't have staff. So if you have the staff, or if we can increase our staff, then we can allow you to use our facility. We don't have, if we're competing, for instance, Douglas County is about 40% at capacity. So they have plenty of space. But Douglas County and Fulton County are competing for the same limited number of applicants to staff. So if they can't get it and we can't get it, we're just, we have to look for further options.
Would you describe the recruitment efforts and if you're currently hiring?
We are hiring. We have one of the best onboarding packages that you'll find. Our board, and this is thanks to our board of commissioners. Like I said earlier, we pay the best incoming salary for any deputy or detention officer. We also are giving $10,500 signing bonuses. We have gone. We've increased our recruiting staff. We have explored every opportunity, and I believe that we're one of the destinations of choice if you want certain things. However, of course, it's kind of hard when everybody knows that we have the facility that we have, but we still are able to compete with just about anybody else. But everybody is experiencing the same attrition and retention efforts.
Okay. And if you'll look in that notebook, Exhibit A, is that the letter that Sheriff Labatt sent to all the sheriffs in the state of Georgia?
Yes, it is.
Okay. And then if you'll look at Exhibit E, if you don't mind flipping back, can you tell us what this is?
Okay, so this is a weekly status report of that details our population and our population by outsourcing, where we're sending people. We get this often, but it's also available to everybody. The sheriff, and you always hear in our agency, you always hear the word transparency. All of this information is also available on the sheriff's app, which so. You see exactly what our population is. This is as of September 14th, but if you go on our app now, you can see what we had as of 7:30 last night.
And would you be able to speak to generally what would be different between 7:30 p.m. last night and this Exhibit E?
Yes, there's some significant differences. For instance, Alpharetta, just that's the glaring one. The max capacity is 50. At that time, we had 22. We're at 50. We were at 50 yesterday. I'm sure it may have changed. I don't know. Things change daily, but we're at max capacity. Our main jail population. It has decreased because of some of the efforts that I mentioned before. So yeah, there's been, as far as outsourcing, for instance, you see Marietta Annex, and that's Marietta Street, not the city, but at the Marietta Annex, which is right behind our Rice Street facility, it only shows 67 right now, but that's because we could have released, 10 or so people the night before. You never know. But most of these efforts, and for instance, I'm looking at South Annex as well. South Annex number has increased dramatically as well. But these numbers change, but you can actually track them daily.
No, thank you. And if you go below that, though, it shows outsourcing locations too. Is that correct?
That's correct.
And will you explain to the court, like what the general arrangements are with each of these outsourcing locations?
Yes. So each one has a slightly different rationale. And I can explain them. Most of them, if you notice, have a max capacity. That max capacity is generally dictated by like an agreement or MOU or something like that. As I mentioned before, with Cobb, we have an agreement with them. We have the ability to send them 500 inmates if they had the staff. They don't have the staff. So they're not going to allow us to send more than what we have. So although they say, well, yeah, if we could, we'd allow you to do, send 500 inmates. Right now, we can only take, 228. And so they, again, that's the staffing issue. They're facing the same challenges that we have. If they or we were able to, add additional staffing, we could possibly find some type of arrangements where I'm sure they would allow us to staff there, but that's just not possible. Despite the efforts we've spent, as I mentioned before, we have probably the best package that you're going to get coming on board. The same with Forsyth. I know that for a fact is at 70. And I know just this past week, we made efforts to see if they could increase that. They're just not able to do it. And so we're stuck with the operational capacity, and we make, weekly transports to fulfill those positions that have been released or other. And I've explained already in detail, ACDC, the challenge there, that one is huge. If we could, we would definitely, with ACDC, like I said, there is two things that impact the number there. But I know that we can raise this even more with our current staffing, but we have the challenge of dealing with their bureaucracy, for lack of a better term.
Have you ever turned down any space that was offered to you to house detained individuals?
Not once.
If you'll look at the following exhibit, Respondents Exhibit F, what is this document? You familiar with it?
Yes, this was developed to explain the differences in capacity, whether it be functional capacity or operational capacity. It just tells literally what type of or the amounts of detainees a facility can hold based on various factors.
Is this accurate to the best of your knowledge?
Yes.
Okay. And then will you flip back to Exhibit B, please? And what is this document?
This was an email that we received. Let me see. This is an email that we received. We were actually kind of surprised at first. It was from the Public Defender's Office.
I'm sorry, B?
B?
B as in boy?
This might be, yeah, this is B. So actually on the thing I see it says C. So what's B supposed to be?
It is the
I see it. It's just
September 20th,
in the wrong
2022
place.
letter?
Yeah, this is the wrong place.
Okay.
Okay, this is a letter from the sheriff to the National Institute of Corrections. Like I said, we were leaving no stone unturned to try and find avenues to address the safety, because, of course, everybody has seen the high profile incidents that have happened at the jail. And we have been looking for any opportunity to find some kind of way to alleviate those stressors. So the sheriff, we created this letter. We created this letter to send requesting help, whether that help was programs, whether they were review of policies, a number of things.
What response, if any, did you get to this letter?
It was somewhat of a delayed response at first. I think that was due to a changing in their directors or something like that. But since then, it's been extremely positive. They've visited, and have already started their analysis.
We're also talking today about potential outsourcing further away
Yes.
from Atlanta. Will you please tell the court about any efforts or how those came to you?
Yes. So the Fulton County administration, the county manager, chief operating officers, and others, they've been great partners in helping to find ways to alleviate the stress. They have actually introduced us to both facilities that we visited. They basically had started talks and introduced us. We did some preliminary talks over the phone, and then we made a visit. We visited Geo in Folkestone and CoreCivic in Tallahatchie, Mississippi. They invited us. We went. We evaluated it. We thought we understood exactly what the rationale was, and we were sold. We think that it was a definite benefit, because if you immediately take 500 people out of Rice Street right now, it's going to be a much safer environment. And it's going to be a much safer environment because the staff to inmate ratio would be so much better, and we'd be able to separate the inmates in a better way. So of course, it's not something that we would want to do, because it costs a lot of money, and it requires a lot of logistics, and it's not expedient. People just don't want to until they see what they have to offer. And in particular, the one that we seem most drawn to, because we received the CoreCivic one kind of late, and we went along to go visit, but it really wasn't the biggest driver, because we had a little bit more talks, a little bit more fruitful discussion with the people down in Folkestone.
And that's Geo in Folkestone?
Yes.
Okay. Will you explain where you are with Geo in Folkestone right now?
Well, I can tell you that there's talks and negotiations, but that really doesn't involve us that much, because this is a county endeavor. And so we agree, and we know that this will immediately help with the safety. But we talk in general to make sure that it's a fit, but we have turned it over. County administration is running that.
Okay. So you're just waiting to hear back?
Yes. Every once in a while they call us to, because they want to compare, to make sure it's something that is acceptable. But we're waiting for them. We're waiting for them to negotiate, and because the Board of Commissioners, county administration, they're going to fund this. It has to go through them.
And will you tell the court about, specifically with CoreCivic and Mississippi, what conversations have been had?
Well, with us, it's been somewhat limited, because like I said, they were brought in kind of late. I think they've been used more like for a comparison purpose. But there hasn't been, we talked with both groups. We visited both, but we had more conversation because the Folkestone group was brought in earlier and because it fit. But the Mississippi option, it was just another option. We had to explore it based on the safety we had, and based on what we need, we had to explore it. But there hasn't been much conversation, especially there may have been more with the county, but not much more. I know there hasn't been more than Geo. And they're definitely, from the Fulton County Sheriff's Office, we have had limited conversation with CoreCivic.
What do you understand CoreCivic would have offered in the way of transportation or transportation partners?
Well, they have they do have a partnership. When we visited, out in the parking lot, they did have buses, and they really, both groups would go out their way to accommodate as far as getting inmates here, because our focus is we want to make sure that we're accessible when needed for courts. One of the questions as we were touring, we were checking on is to make sure they had Zoom capabilities and that kind of stuff. But we wanted to make sure that they were accessible to come here for court. We are also in those efforts, and because we know that the county is exploring that option, we have started to vet our population, because there are certain parts of the population who, no matter where they're going, I mean, it doesn't matter if they're going from here to Cobb County, we're going to keep in house for certain reasons, whether it be medical or whether it be cases that are impending. But it's the same there. But and I can't tell you exactly which one, but I know that I've heard like sometimes up to 2 to 3 different transports per week, so that we can accommodate if something does come up, something changes, and we need to get an inmate back here for court. We have that ability to do that.
Okay. And do you know the name of the Core Civics partner for transportation?
I can't remember.
Okay. Transcorp?
That's it.
Okay.
Yes.
And would there be any remote trials conducted at the Core Civic Mississippi location if that were to?
They have the ability to, but that wasn't overriding factor. We wanted to make sure that was possible, but that was not one of the overriding factors. Because we wanted to make sure that should that counsel or inmate want in-person trials, that we were going to try and accommodate.
And I do want to turn to that contract. Does the court reporter have that exhibit?
It's actually right here.
May we borrow that?
Of course.
Yes.
I only have that one, but that's the witness copy.
Perfect. Show you what sort of. And
Okay.
have you seen that document before?
Yes.
Okay. And what is that document?
It was a preliminary, I guess, for lack of a better word, preliminary proposal that was submitted. We asked for as much information as possible from both, because we knew that the board was interested in this. So we tried to get as much information as possible to present to them. It's very preliminary, and I say that because this was what was sent, but this is not something that, for instance, I know that every single contract that we get, we send to our general counsel for review, sometimes to the county attorney for their review, so that we put we have our input. It's a back and forth type thing. So this is very preliminary. And I say that because it didn't even go back. It just came. And it was just one of the many documents that we received.
Is there any information missing in that draft contract?
Not having read it completely and just looking at it just now for the first time in maybe a month or so. Let me see.
What's the price per services in this contract?
Well, that's what I just was looking right here, and it says, that's what I was kind of looking for. I don't see it. I don't think that was, if I'm not mistaken, there wasn't one at this time because we were asking for more, because we're still, that's how preliminary it is. I don't think we came up with any pricing at the time.
Would you look at page 4, paragraph 13?
Okay.
To specify how much Core Civic would be compensated for providing housing for detained individuals?
No.
Would you look at exhibit C? And I know one of them's out of order, but it's an August 22nd, 2023 email.
Yes,
Do you have that?
I do.
And what is this What is this document?
This is an email from the Public Defender's Office to Amelia Joyner, our Chief Counsel.
And what's it discussing?
This is regarding My Justice Portal. And if I'm not mistaken, if I remember, and I don't know if this is the email, but I know that I had never heard of this until the public defender brought it to our attention, which actually we started looking at it even more so. Although it was brought by the public defender, we really weren't involved in, and I see it says that that they were working with some other partners in discussing this. We weren't a part of that, but it was convenient though, because when we started visiting some of the other sites and we started talking, because we're trying to, like I said, we're trying to make sure we're providing the best we can for the inmates. This actually was one of the things discussed, and Geo Group in particular loved it. And I believe that they had already started exploring options to do this.
Okay. And then if you look at Exhibit C, which is a July 25th email, I'm sorry, an August 22nd email.
Okay, I'm looking at the August 22nd.
Yeah, it was my fault.
Let me
I
see.
read out the date wrong. So what you were just describing was related to the August 22nd email. Is that correct?
That was, yes.
Okay, and then if you'll look at
And I'm
the
looking at-
July 25th email now.
Yes, now I'm looking at July 25th.
And this regards the same thing, the My Justice
It's the
Portal?
same thing, from the public defender's office to the sheriff's office, specifically Ms. Walsh to Ms. Joyner, copying Mr. Kenner. And basically, and like I said, this was the introduction to us from the public defender's office.
If you would look down in that first paragraph, 1, 2, 3, 4, 5, the sixth line, it starts with the word individualized file. Do you see that?
Yes,
It says so that they can view discovery, send email, and otherwise communicate with their attorney without them being at the jail.
correct,
And is that your understanding of what My Justice Portal does?
exactly.
What's the current policy for family visitation or friend visitation at Rice
We
Street?
don't have in-person visitation.
How long has that been the case?
Well, since COVID, I believe, but I've been here 2 years. So that's my reference.
Will you look at Exhibit G, the last one we need to go through here? You recognize this document?
Yes.
What is this document?
This is Ms. Joyner's response to Mr. Kenner and Ms. Walsh.
Regarding what?
Regarding I remember a Saturday morning when Ms. Joyner called and we discussed the letter, and it was the letter from a letter objecting to us moving out of state, moving inmates out of state. And this was in direct response to that letter.
Did your office get anyone else to reach out about this from the public defender's office?
This was the first.
Have you ever considered filing a mandamus action against any other sheriffs to require them to accept detained individuals from Fulton County?
Not at all. We just asked them. We asked them, and like I said, one thing in the law enforcement community, they're good partners. I mean, we literally deal with other counties on a daily basis. Matter of fact, on one of the chart that showed the numbers, if you look down and let me tell you exactly which one, the Exhibit E. If you look down at the population by outsourcing, and you see where we have like one inmate in Gwinnett, one inmate in Spalding, and all of that, we take advantage of every opportunity because we have good relationships with all of them. And so if they have the space available, they're going to make it available to us. These inmates, you know, and most of these, we don't have contracts with. If they're able to help, they will. If we have to do a mass number, of course, we might have to do a contract or something like that. But if they're assisting for whatever reason, the relationship is well enough where it doesn't require any type of, you know, we don't have to force anybody. Everybody's gonna assist as much as they can.
My final question is, what has occupied most of your time as chief of staff for the Fulton County Sheriff's Office?
Safety of our inmates and our staff, whether it be here at the courthouse or at the jail, but specifically a huge portion. Of course, my job is a little bit different than, say, like the chief jailer. My job is operational. So I'm dealing with human resources and finance and IT and all kinds of related things like that. But most of that is in assistance to try and make sure that we put our people in the best possible position. So if, you know, as far as HR, retention, hiring, recruiting, that kind of thing, we're doing as much as possible specifically to help that jail.
Thank you. Thank you for your work. I have no further questions, Your Honor.
Russ.
Back here.
Okay.
You don't have to
Oh, okay.
now, but you may
Okay.
have stickers on. Good afternoon, Mr. Schultz.
Hi.
How are you?
I'm fine. Thank you.
Good. Am I pronouncing that right, Schultz?
Yes.
When the sheriff's office went to visit the facility in Tallahatchie, Mississippi, the core civic facility, were you part of the group that went down to visit?
Yes.
Who was part of that group that went to visit in person?
Off the top of my head, the sheriff, the chief counsel, myself, our project manager, the chief jailer, assistant chief jailer, and I believe there was one of our jail investigation members. I'm not sure if I said special projects manager, and another major from the jail.
Did anybody from the Fulton County Board of Commissioners go to that visit or participate in that visit?
No, we talked to them once they provided us the information and introduced us. But when we invited them, we were specifically said that, you know, we're going to handle the one part. You all are the professionals when it comes to the jailing part. We need you to see that.
So when you say we invited them, did you all invite the commissioners to come to?
No, not the commissioners,
meeting?
no.
Okay. So who were you referring to when you said we invited them?
To the county manager or the chief operating officer.
Yeah. But they did not come, right?
No.
Was it just one visit to that facility in Mississippi, or did you have multiple visits?
One.
When's the first time, like the earliest date you can remember that the sheriff first looked into sending detainees to out-of-state facilities?
That was the first time, and I have to look at the calendar because in my only point of reference is the date that we went to visit them. It was earlier that week that we were introduced to them. So that was the first time. So I can look at my calendar if you want me to.
My next question was going to be, when did you all go out for the visit? So that is what I was going to ask.
Yeah, I can. Look
If
at
you
my
have it
calendar.
readily available, I'd appreciate that.
Let me see.
Yeah.
13th or 14th.
If you take a look, it might be around September 13th or 14th. Thank you, David. We can come back to that,
Okay.
just so you don't
Oh,
have to.
I'm sorry.
search
I
your
see it
phone the
now.
whole
I'm looking,
time.
I see the flight now.
There we go.
That was the 13th. Atlanta to Memphis. So yes, that was the 13th. So we probably, I could be mistaken, but I believe it was like the 11th, that Monday, where we first actually talked to them. And then we flew out there that Wednesday, came back that next day. It was, and it could have been, possibly could have been Friday, but I know it was just a few days before when we had our first conversations with Core Civic.
And that was September 11th,
Correct.
2023, right?
Correct.
So when Chairman Pitts was interviewed by WXIA on September 6, 2023, and he told the interviewer that the sheriff is expected to visit those two prisons by the end of the week, and they hope to start moving some of these inmates out within the next 2 to 3 weeks. Had you all not even been introduced to the facility in
He hadn't talked
Mississippi
to
yet?
them. I know county administration talked to them, but I was pretty much the point of contact. And I know I have not talked to them. I talked to them when the chief operating officer introduced us, like I said, several days prior. So like I said, I don't know if that was that Monday or that Friday, but it wasn't too far from there.
And when Chairman Pitts referred to the hope to start moving some of these inmates out within the next 2 to 3 weeks, was there any plan in place as of September 6th to start moving inmates out within the next
No.
2 to 3 weeks?
That wasn't logistically possible.
That was going to be my next question. Would it even be possible in that short amount of time to
No,
move
but
inmates?
not with the kind of vetting that we would do. Because like I said, if somebody that we know is going to have like a case, they're going to stay here. So the type of vetting, yeah.
So as of September 6th, had you ever spoken to Chairman Pitts about moving inmates outside of the state?
No,
And do you know if anybody else at the sheriff's office has, not necessarily to the facility in Mississippi, but just period, to move inmates out of state, period?
out of state, no.
Do you have any idea, as you sit here today, where Chairman Pitts would have gotten that 2 to 3 week timeline from?
No. And if I may, it took us longer to move to ACDC than 2 to 3 weeks.
We looked a little bit we looked at the letter that Sheriff Labatt sent out to the other sheriffs asking about available beds. You remember that?
Yes.
Did anyone from the sheriff's office go out to meet with the counties outside the metro area in person to talk to them about available space?
He talked to I can't say 150 whatever sheriffs, but he talked to a lot of sheriffs personally, because like I said, he has a personal relationship with all of the metro sheriffs, but then they also have sheriff's conferences. And this was a topic of discussion purposeful. When he went there, it was he was looking for help.
And when he went to those conferences, were those conferences of national sheriff associations or were they
No,
Georgians?
Georgia. Well, he's gone to those too, but the ones that I'm talking about in particular were the Georgia Sheriff's Association.
And do you know whether outside of the discussions he had at those conferences, he made any visits to facilities outside the Metro Atlanta area?
I can't tell you if he's been to any outside the Metro Atlanta area. Inside Metro Atlanta, definitely, yes.
You were asked by Mr. Dryer about in-person visitation, and you said the Fulton County Jail doesn't have in-person visitation. right?
Except for counsel.
That's what I was going to ask you to clarify. That doesn't include public defender counsel, right?
Correct.
Anybody from the public defender's office is able to meet with a
Correct.
detainee in person. And I know this is supernatural in conversation, but sometimes you answer me before I finish my
I'm
question.
sorry.
And it's not me, it's the court reporter.
Gotcha.
It makes her have to scramble a little bit on the end. So just give me a pause before you answer, please. So I want to go through with you. You should have it in front of you, though. That stack I put on the corner should have little stickers in the bottom corner that are in numerical order. I want you to turn to 8, 9, 10, and 11. It should be the last 4 documents in that stack.
Okay.
Okay. Starting with number 8, this document, it says May 2023 on the document, but the file as it was produced to us had a date of 9/13/23. The document marked as Exhibit 8, is that something that you all requested from Core Civic, or did they just send that to you all as a point of information?
I'm not sure if this is the exact document, but I know that when we were introduced to them, we were given something that looked very similar to this. But I'm not sure if this is the exact document, but we were given something initially.
Okay, and looking at this, the bottom, the last 2 paragraphs, the second to last paragraph gives a general per diem between $75 and $80 a day. Do you see that? It's the second to last paragraph. Cost would depend on a number of factors.
Yes, I see it.
And is that $75 to $80 per bed per day or per detainee per day?
That's how I read it.
Okay, and looking at the bottom, the last paragraph on that page, Mr. Dryer asked you about that TransCore subsidiary. Do you see that language at the bottom?
Yes.
It gives, they give you an estimated cost of $7,000 per trip, and up to 3 round trips per week. Do you see that?
Yes.
For 30 inmates each time?
Yes.
And had you had to vet before then the cost of transporting busloads of detainees back and forth to Fulton County on a regular basis?
No.
I want you to turn to Exhibit 11. This was another document that came to us from the sheriff's office in response to an Open Records Act request. I want to direct you to the bottom of the page. This too has some numbers in it, but they're a little different from the last one we looked at. It still says the per diems of $75 to $85 a day, but if you look at that last paragraph, it talks about the transportation costs through TransCore. And it says for Fulton County, we propose an initial ramp up by ground over 3 weeks. Each rotation would include 30 inmates with moves of up to 120 per week for a total of over 4 trips for a total cost of $87,000. Do you see that?
Yes.
And then it says for ongoing transports, we suggest a standing trip by bus of 30 inmates each way every 2 weeks. And the per trip cost is going to be $13,000 for 60 inmates round trip. You see that?
Yes.
Do you know why the costs increase from one to the next?
I don't.
Had you all engaged in any specific negotiations or discussions about the cost of transportation at that time?
I don't know the timeline, but I can tell you that we were requested more information regarding financials. And so there were some calls that were made, and this possibly could have been one of those, and because that was the other thing about Core Civic's initial proposal is that they seemed very light. That's kind of why we kind of shied away from them and lean more towards Geo, even though it wasn't our choice, but that's seems to be the people we talk to the most because the Court Civic just didn't provide a lot of details.
Why does the sheriff believe he's authorized to send detainees outside of the state?
I can't answer that.
Well, does the sheriff's office, is it the sheriff's office position that it is allowed to transfer detainees outside the state of Georgia?
That's a legal question that I'm not, I don't make those determinations.
Well, you're here today as a representative of the sheriff's office, right?
I am.
And you all went to visit facilities outside the state of Georgia for the purpose of potentially transferring inmates to those facilities, right? I mean,
We
excuse me,
visited-
detainees to those facilities, right?
We visited as a suggestion and as an opportunity, yes.
And as you sit here today, you can't tell me whether you think the Fulton County Sheriff actually can send detainees to.
I
those
can't
facilities?
answer that.
Objection, ask and answer, Your Honor. Argumentative.
All right, sustained. Let's move on.
Mr. Dryer asked you today, excuse me, let me rephrase. Mr. Dryer argued earlier today that the transfer of detainees is not imminent. Do you know what does the sheriff have a definition of what imminent means in terms of these potential transfers?
I can only go off of my definition of imminent, meaning that we are on the verge and ready to send somebody. It would take some work, some ramp up. Of course, exploring these possibilities, in addition to exploring these possibilities, in a effort to reduce the population, we began to vet our population to see, but as far as setting up a complete logistical plan, we don't have that in place yet. We have the expertise contracted to help us come up with a plan. So I don't think that it would take, a long time, but meaning a long time, like I said, it took, some time to move to ACDC. We didn't move in a matter of weeks.
Does the sheriff's office have any current plans right now in place to move detainees out of state?
No,
Do you know why the sheriff's office would not agree to refrain from transferring detainees out of state while this petition is pending before the judge?
I don't think he was asked specifically, other than a lawsuit, but this is not politically expedient for him. And if he was forced to do it because of some drastic measure, we'd have to come to that when we get to that. But right now, we're not there.
So are you not aware that we asked the sheriff's counsel twice to agree not to send detainees outside of state during the pendency of this petition?
I don't know of the exact conversations. I wasn't a part of that.
Just 1 second, Your Honor. I believe I'm done, but let me check my notes. I don't have any further questions.
No to redirect, Your Honor.
Well, let me ask a question here, sir. So you said it's not imminent, that it's not happening right now. I guess another way I would phrase the question is, it's still on the table? Is it still an option that the sheriff's office anticipates they may draw upon at some point in the future?
I can't see that personally, but I cannot. The way that the negotiations have been going between the two, but with the county and these two facilities, I don't see that.
Okay. Any redirect or cross on that point?
No, Your Honor.
All right, can this witness be excused? Mr. Dryer.
Your Honor, we have no further witnesses.
Can this, well, all right then. Thank you, sir.
What did you ask me, Your Honor?
If you could be excused, that's all. Okay.
Just leave this stuff here.
When I get it to the court report.
Yeah.
Okay, so the evidence is closed. I guess I should ask formally if the petitioner had any rebuttal.
Yeah, I don't have any rebuttal.
Okay, so let me just kick it off at the outset here and ask Ms. Warner if, based on the evidence that's been presented, specifically the issue of, I guess for lack of a better word, imminence, is there still something that's justiciable here? Is this still actually an issue that requires a ruling from this court?
I believe the writ is still a justiciable issue. I think that the request for a TRO and an interlocutory injunction, based on the imminency, is no longer an issue given the testimony. But I do think there's still a reason for the writ.
Well, let me ask you this. I mean, it seems like there does seem to be some kind of requirement, and maybe you can direct me somewhere in the statute or the case law, that this has to be something that's actually at issue. Otherwise, are you saying theoretically a public official could have a mandamus for every statutory duty and just being told by the court they need to comply with every statutory duty listed without the threat of them ever being violated? Like that seems like an odd
That's not
scenario, right?
right.
So there has to be some kind of threat, right? That a duty is about to be violated. Do we have that here?
Well, what I did hear from this witness, Your Honor, is that the Board of Commissioners is making active, having active discussions and engaging in this process. And up until just now, it was our understanding through the board chair's public statements that transfers were imminent. So I'm at
Well, look,
here for how to reconcile those two, because that certainly was the understanding.
well, we can break for 10 and you can kind of think about it and maybe talk with your I guess, client, for lack of a better word, and see if this impacts your analysis. But that seems to be the big glaring red sign right now is, what are we still doing here?
I would like that 10 minutes
Okay.
to assess that. That was new information to me, Judge.
Understood. So let me know when you need me.
Okay, thank you. Go back to the top.
They're stepping out. Should we stay? Great idea.
Yeah, I just have to. I have to send. Okay, that's right. So I was a legislative liaison for the GBI.
Oh, good.
Yes, I was like, really?
Good.
Yeah.
Yeah, I worked on the ending shackling of pregnant women, and I worked on getting rid of the R word from the Georgia Code, and I did.
Right. Okay. Yes. So yes, I was retired from the GBI.
Oh, yes.
You can send it. Okay. Yes. Thank you.
You know, I used to. Like to the whole thing.
Yes. Yeah.
I gotta start looking at food. I never, but you know, they have that food thing that the county does. I always forget about it. I would have. But you didn't share it,
I don't know how to do it.
Yeah, we
Someone. They said that for me. They said it's what
The only reason I don't use it up here, every time I see it, I can't wait to eat that.
Yeah. So they don't know it's in my number.
When I first started working, I had a full tilt.
Oh, yeah.
It was a full tilt, so there was all kinds of, yes. Yeah. That was, yep. All kinds of, so lunch was all right.
They
They been saying that.
They were saying that, yeah.
I'm
Because every time somebody try to do something, pull out.
Yep. But they still say that they don't do a lot of development for the goats.
Yeah,
Now that's.
yeah,
Yeah, that one.
yeah.
South downtown.
Plus, you know, we live over in Grant Park, you know, you know, food.
Oh, really?
That's it.
What, it's gonna be like, what's that place over there? Yeah, it's gonna be like.
Well, it's gonna be, so it's like more money from neighbors than money from development.
Oh, really?
But this is gonna be more smaller. More like. Yeah, but like, where stuff is closer, but not with home. Not this- Yeah, it's more food. stalls,
Yeah.
Like, it's just like local roads.
I can see that because that area has come up. It's kind of crazy from all the way from like the Summerhill area, all the way back.
Yeah,
to
that
Grant
whole
Park.
Summer Hill, yeah.
And
North
that-
George Avenue, yeah.
And it. Georgia State for a lot of it, because the Braves didn't do nothing.
Yeah.
They did nothing. The Braves made it kind of different over there.
Exactly, exactly. We're still dealing with it. Like all the roads over there are one way, you can't get anywhere. And, but yeah, and that's not to, yeah, I mean, whether Kasim Reed did the right thing or not is beyond me, but the Braves, when they were gonna redevelop that, they only wanted to have 3 restaurants
See, that makes no
outside,
sense.
right? Because they wanted to drive everybody inside for concessions.
Ah,
But they're only playing 81 games a year. We live there the rest of the
Yeah.
time.
But that battery.
Come on.
but Georgia State brought that area up.
I know.
Yep.
100.
And you know.
And you know they're gonna cater to those students, even though the students are here full time, but they're gonna cater to those students.
And it sounds like public. David.
Do you want to she should send me the minutes, but do you want to send it to me?
No, whichever one, I was kind of, I still don't want to do was ask you.
We can
which
send
one
it to
to-
Mike. But she'll send it to me. I'll immediately send it to you. But we're just gonna send it to the county.
You get my card?
She will send it to me.
Okay.
He's money.
I don't know what I was thinking. Why
So what y'all would.
Madam Court.
And resources. You know how many inmates just want to be. He said his hand, he got up and every day.
Right.
Yes.
That's what you see.
Just on a frivolous litigation. That's what it's about.
I believe.
Ready for the judge?
Yes.
Sit right here.
This year, why we pilot pants. Since high school. This was in grade. Like.
Mhm.
Mhm,
Mm. Can you order us?
Right, see the court.
That's it, y'all. Okay, Ms. Warner, what are we doing?
I got a couple of points to make for you. Now that I've had a chance to confer with my client. Looking at the provision about whether there's a mere suspicion of fear, we can't say that this would be granted on a mere suspicion or fear. We have pointed out to the sheriff, including before the petition was ever filed, that he doesn't have a right to send these inmates out of state. We asked twice directly if he would agree not to, even just for purposes of waiting for this petition to happen. He said no. More importantly, the sheriff's office, through his general counsel, and we submitted this into evidence today, went to the Board of Commissioners and affirmatively represented to the Board of Commissioners that he has the ability to move detainees out of state. It's in the September 20th hearing testimony that we submitted today. and said that the statute contains the word may and affords him the opportunity to do it. We know that the board is looking. We know that the jail crisis continues. The sheriff's office spent the majority of the time putting the evidence in today, telling you that the jail is unsafe, telling you that there are no available beds within the state of Georgia that also have staff where they can send people to. And the sheriff hasn't said he won't do it. He's the only person who can do it. We know that mandamus applies prospectively, so we can't wait for the sheriff to do something that we think violates the law and then come to you, Judge. They spent the whole day telling you that the conditions are right to move people and that the only place that they can really be moved is out of state. And now they're saying, well, never mind, we don't really think we're gonna move anybody, or we don't have any current plans to move anybody. And Judge, that is, I would say, gamesmanship at its finest. I think the mixed messages that have come to the public defender have been presented to the public, have been presented through the press, and that were presented today show why we need something directing the sheriff as to his rights. And we note in our petition, Judge, in paragraph 27, that mandamus is appropriate when there's a situation where only a judgment that forcibly binds the sheriff to act, like a mandamus petition, would resolve the legal issues that we've raised. And that case was SLNG versus McGinnity. It's 294 GA 657 2014. So Judge, we're not at this point able to say, based on the information that was put into evidence today.
You claimed before that mandamus was prospective. Prospective. What's your authority for that?
Sure. The case is Atlanta Independent School System versus Lane, 266 GA 657, the 1996 case.
Say that last part again.
266 GA 657,
All
and
right.
it's a 1996 case.
And what does that case hold?
The specific quote we cite in our brief is that, and this is in quotations, mandamus relief applies prospectively only. It would not lie to compel the undoing of acts already done. And this is so even though the action taken was clearly in violation.
So on that quote alone, I think I'd need some more context to support
I can pull the case out, just give me one.
the point I think you used the quote for. Certainly it can be prospectively, but that what I took that quote to mean is if it's something that's already been done, then perhaps it's a different analysis.
Sure. I have the case here, Judge. This is where the petitioner sought a declaratory judgment that it was a public utility, and it filed a mandamus petition to try to get the court to direct the commission to accept its ad valorem tax returns rather than to have the county accept them. The court remanded the case to determine whether the tax appeals court was an adequate legal remedy such that mandamus wouldn't lie. So the actual main issue in the case was whether there was some other remedy available to the petitioner that they would not require mandamus. But let me find the quote. The question before the judge before the court, when that particular site was made, was whether the mandamus claim against the petitioner was precluded because whether the mandamus claim against the commissioner was precluded because the petitioner had a pending tax appeal in a county court. And the court was looking at whether or not that mandamus would apply if there was some other remedy or something out there.
Your Honor, may I respond when appropriate?
Of course, you have other points, I would imagine.
Yeah, that was the LNG case. The other case was the Atlanta Independent School District case, and I apologize. I'm looking for it in my stack of cases right now. Okay, this is the case, Your Honor, that talks about prospective mandamus relief. This Atlanta Independent Schools District case, there was a portion of the case that dealt with mandamus involved the taxpayers' claims about the use of local tax dollars for schools when the Constitution had certain provisions at that point about ad valorem taxes being used to fund education. And the money that the petitioner was complaining about had already been spent. And the court said in analyzing his petition that, the quote that I referred to, that mandamus relief is only available to address a prospective action. It's not gonna apply to undo the past tax allocation.
Right, so they denied mandamus in that case, that the quote comes from. Okay.
Yeah.
So again, I think I'm still a bit unclear where we've blended some of the issues involved between an injunction and a mandamus. And I wonder if you could address, I think, counsel's point to mandamus is generally used to compel performance of a legal duty. Once you've established that one exists, it's, there's a demand that a public official do something and they've refused to do it. What would you say is the legal duty that the sheriff has refused to do in this case that you're asking to be compelled?
The sheriff has refused to the sheriff's position, I think, is that he doesn't have to send detainees solely to other counties within the state of Georgia, even though we have raised that legal issue, said that that was his duty, asked him to refrain from sending anyone outside the state because of that duty, and he has refused. And in fact, his office has affirmatively represented that he has the authority to send them outside of the state. Judge, all of the representations up until today have been that this was underway. And I think to have the sheriff's office now come in here at the 11th hour through a representative and say, we don't really have plans to do that, flies in the face of over an hour of testimony that the sheriff, not testimony, excuse me, an over an hour long presentation that the sheriff's office gave to the Board of Commissioners in a public session about all the steps his office had taken, including budgets, including plans, including the meeting, including reiterating to the board that there was no other space available in Georgia, including in response to those commissioners' questions about why can't you find a way to staff local bed space? We can't do that. This is the only option.
Okay. Anything else you want to move on to address?
Other than the issues that were other than what I put in my papers, Your Honor, I don't have anything else to address on this kind of last minute about face issue. I feel like I've reiterated either through the testimony that came out today or the points I raised just now, that the sheriff's statements that it doesn't intend to do this are not consistent with the facts that we've presented to you, which is that the sheriff's office does have an intention to do this, has taken affirmative steps to try to make it happen. And I think is only saying it now so that we can get this petition out of the way.
Okay, Mr. Dryer.
Your Honor, thank you. So I want to just clear up a couple things that weren't misstated, but could create a different impression. The petitioner sent an email on a Saturday to General Counsel for the Sheriff's Office objecting to this. General Counsel's office replied back the same day, we'll be happy to sit down with you. That email is in front of Your Honor. 2 days later, they filed a mandamus petition. There was never a request to delay this until I was already retained. The communication about agreeing to not do this was made to me, but in relation to scheduling the initial hearing. We wanted the initial hearing to go forward as soon as possible. We were hoping it would go forward 3 weeks ago. We declined to do that. So there wasn't an offer made to the sheriff's office prior to filing suit. There wasn't a discussion, even though there was an invitation to do that. And as far as what is imminent, what I don't even think Folkestone is imminent, because Folkestone obviously is in Georgia, but we don't have a contract. We don't believe the BOC has signed a contract that has not been funded. That's got to be passed through the BOC. But if anyone's closer, that's definitely way closer. So we haven't tried to obfuscate or hide the ball on this in any way, but it's not imminent, Your Honor. It's not right. And clearly there's no contract, no funding, no designated individuals that are going to go. Your Honor, I think on your point on mandamus relief, I think this should be phrased as potentially two things. One would be a prohibition action, prohibiting us from doing something. But also, I think but that would also potentially get into.
With this, I mean, I don't think a trial court even has the authority to do a prohibition against anyone other than I think it's, the way it's phrased is against other courts. So I don't think I can issue a prohibition against a public official.
Well, we found some case law that suggested the flip side, and I can pull it, but Your Honor, regardless, it's outside of the mandamus statute itself. And the other one is, Your Honor, I mean, the declaratory judgment action is specifically exempted from sovereign immunity under the new constitutional amendment or fairly recent constitutional amendment. And I think that's how the relief should have been phrased. But I think also the Board of Commissioners should have been included, which, brought this opportunity to us, would fund it, and is negotiating a contract if whenever everyone gets finalized. So I think that would be the way to go. But Your Honor, I mean, if we're talking about bad faith, the petitioner not
I
going
mean, I'm not talking about it. So let's stay on the merits.
100%. So anyway, if there was, for this to be right, I think it would need to be a declaratory judgment action involving the Board of Commissioners as well as our office.
Okay. Anything else in general, Mr. Dryer? All right. Ms. Warner, any final thoughts on the declaratory judgment aspect of it?
I just wanted to address that last comment. The Board of Commissioners doesn't have authority to act under that statute. It's only granted to the sheriff. The statute specifically says what the sheriff shall do when conditions are unsafe. So I think had we brought the board in, the board would be saying we don't have the authority to act under the statute to move detainees. That's the sheriff's power. The legislature has granted that to the sheriff.
Okay.
Finally, final point, Your Honor. Again, there's not a clear legal duty that we are affirmatively required to do in this situation. I could evolve into, if we had to go to a close by county, it's just there's an impossibility there, Your Honor. But they haven't phrased a clear legal duty, and we don't believe it's right, Your Honor.
Well, and I'm curious, just to go back to the first issue we talked about at the outset, where you felt there was some kind of a reasonableness standard to mandamus. Can you point me to anything where that kind of a weighing of the equities has happened in a mandamus context?
Yeah, it was a great. It really caused me to think, and so when I look at a clear legal duty, when I look at the other standard, and I'm trying to think of maybe even a jury weighing this, it just gets like, it's very confusing, because what's a jury going to decide then? I mean, it's more about, these are more legal questions, which obviously is why we wanted a bench trial, as did opposing party. But if you're looking at no other adequate legal remedy is available to effectuate the relief sought, and the applicant has a clear legal right to such relief, I do get those are legal questions, but I do think the court has to make a determination on those. And I think that if that does involve looking at the evidence here. So those were important points to us, Your Honor, because we didn't know what else to do. And there are other legal remedies available, declaratory judgment action. And then there just hasn't been an establishment of a clear legal right and duty for us to take for them to enforce an affirmative action from us.
Okay.
Thank you, Your Honor.
All right. Well, I will take it under advisement and issue a written order, hopefully within a week from now. I would hope to be able to turn that around. And just a few initial observations without anything concrete saying that there is some kind of that the court's supposed to wade into these policy decisions, which was about 90% of the evidence presented. I just don't see that as being in my lane. And I can certainly appreciate that at some point, maybe the sheriff's office hasn't been left with many great options here, if any at all. And in fact, the law here may very well be acting like a straitjacket. But if that is what the law requires until we've and if that's the policy decision that the General Assembly has made, I don't think we're allowed to circumvent that just because we have to. I think there are other routes that you would have to go down in order to be able to do that, and they're not easy. But essentially, my reading of that statute, I don't know whether this is going to be determinative at all, but the initial read of it and the case law interpreting it is that the General Assembly did decide to make a policy decision that inmates stay inside the state regardless of what else may have possibly happened. And maybe they didn't contemplate a situation like this where the county just has not kept up with the pace of the population and how many detainees we're expecting the sheriff's office to safely house. And that's not something you can turn on a dime. But that's not a statute I can ignore either. But regardless, there will be a lot of other procedural issues and hurdles we have to jump through and explore to see whether this mandamus petition is something that can even be reached on the merits. I think that if it is denied as not yet ripe for review, then the petitioner is always going to have the ability to refile that in a heartbeat, and immediately they've already got a template of an injunction that they can file right along with it, where the immediacy and the merits are going to be perhaps better particularized here. But anyhow, just with that, we will take a closer look. If council want to submit any kind of supplemental briefing based on today, they're welcome to. They're not required to, but I would ask that be done, let's say by Tuesday close of business. All right. Thank you all.
I'm sorry. I heard a voice, but I couldn't see where it came from.
Ms. Smith, if you want this.